resume our meeting, and we will get underway with item F, which is the contested case hearing for Northwest Metals. And our first slide here, our process slide, just runs through exactly how the EQC runs through hearing contested cases. And so our first step here is that the EQC legal counsel, Gary Vrooman, will summarize the matter, and then we will simply move right through our process. I want to thank everyone for joining us and turn it over to you, Gary.
Great. Commissioners, Gary Vrooman, your legal counsel. I think we only have this one slide for this matter, this item. So the rest of it will be talking, I guess. So I'm here to just give a brief introduction, and then we'll move into the meat of the matter. So this is a petition for review of a contested case proceeding in the matter of Northwest Metals Incorporated. Review is on the record established before the ALJ. In this case, the EQC cannot consider factual material outside of the record established by the ALJ, except for some exceptions that I'll talk about briefly later. This part of what we'd like to do at the beginning of these is just to poll the commissioners quickly and make sure that there are no ex parte communications or conflicts of interest that bear on this matter. That should be noted for the record. So for the commission, an ex parte communication would be a communication during your review of a contested case not made in the presence of all parties to the hearing that concern a fact at issue in the proceeding. And an ex parte communication does not include communication from agency staff or counsel about legal issues or about facts that are in the record. So I would just note that at a previous meeting, the commission considered whether to approve filing a civil court proceeding related to Northwest Metals. At that meeting, the commission was presented in open session with some facts that are part of the record in this matter. The presentation of facts that are part of the record in this matter at a previous EQC meeting is not an ex parte communication for our purposes here. So, Chair, I would ask that you just poll the commissioners, and I would say conflict of interest is some kind of personal involvement in the matter or knowledge of the people involved in the matter that would bear on your ability to be impartial deciders here. So, Chair, I just ask that you poll the commissioners briefly and for conflict of interest and ex parte contacts.
Okay, thank you. Yes, we will do that. Commissioners, when I call your name, please let us know if you have either a conflict of interest in regard to this case or have received or participated in any ex parte communication. Commissioner Barrasso.
I have neither.
Thank you. Commissioner Kyle.
I have neither.
Commissioner Addington.
Neither for me.
Commissioner Mosby.
Neither.
And speaking for myself, Kathleen George, I have neither of those situations either.
Great. So I'm just going to give a quick background, and then I'm going to quickly summarize kind of the commission's options in dealing with this when we get to the end, and have further discussion about that last part, if necessary, as you're making your motion and deciding how you want to resolve this. So the facts that I'm about to describe to you are taken directly from the proposed order, and I'm just going to set the scene a little bit. So Northwest Metals is an auto dismantler and scrapyard located on a 2-acre lot at 7600 Northeast Killingsworth Street, Portland, Oregon. On the morning of March 12th, 2018, there was a fire at the Northwest Metals facility. The fire caused significant damage to the facility, caused the evacuation of surrounding neighborhoods, and burned residences next to the facility. After the fire, DEQ inspected the facility on multiple occasions, as fully detailed in the proposed order. DEQ also issued a remedial action order requiring the company to submit a fire debris removal work plan to DEQ for proper characterization and disposal of waste generated by the fire. On August 30th, 2018, DEQ issued Northwest Metals a notice of civil penalty assessment and order proposing to assess the company's civil penalties and to issue the company an order for compliance. On September 19th, 2018, the company filed a request for a hearing in response to the notice of civil penalty. In May of 2019, Administrative Law Judge Samantha Fair convened a hearing in Portland, Oregon from May 28th to May 30th. the company appeared and was represented by counsel. DEQ appeared and was represented by environmental law specialist Courtney Brown. On August 29th, 2019, ALJ Fair issued a proposed order making the following conclusions of law. 1, the company allowed a class 5 injection system to inject hazardous substances. 2, the company placed waste in a location where they were likely to enter waters of the state. 3, the company failed to completely and accurately determine if residue at the facility was hazardous waste and the company mixed antifreeze and used oil. 4, the company established, operated, and expanded a waste tire storage site at the facility without a waste tire storage permit. 5, the company failed to operate a waste tire storage site in conformance with applicable standards. 6, the company constructed, installed, and operated a full-size stationary vehicle shredder that caused an increase in regulated pollutant emissions without prior written notification to DEQ. 7, the company installed and operated an air contaminant source without obtaining an air contaminant discharge permit. 8, the company violated the terms and conditions of a previously issued DEQ remedial action order. And 9, the company should be assessed a civil penalty in the total amount of $59,015 as further detailed in the proposed order. The proposed order also requires Northwest Metals to undertake various corrective actions to correct the violations. Northwest Metals submitted timely petition for review of the proposed order, and the matter is now before the EQC for issuance of a final order. On appeal, the Commission may do the following. The Commission may affirm the proposed order of the ALJ. The Commission may modify the order and reach different legal conclusions. If the Commission modifies the order, it must explain the reason for the change. The Commission may interpret a statute or rule at issue differently and apply the interpretation to reach a different conclusion of law. The Commission may make additional findings of fact based on evidence in the record. However, the Commission may not modify a finding of historical fact made by the ALJ unless the Commission concludes that the finding is wrong based on clear and convincing evidence in the record. And if this becomes an issue, we can discuss that further. Commission may also remand the case to the ALJ for further proceedings, but the Commission must explain the issue to be considered and the scope of the remand. The Commission may not take new evidence. It must make its decision based on the record. And now I understand in kind of a late breaking development that DQ or the Commission did receive a petition or a motion to take new evidence to essentially remand back to the ALJ to take new evidence. I understand we just got that briefly before the hearing. I have not fully reviewed it. You know, the Commission rules for that, I believe, is that sort of motion was supposed to be filed earlier with the pleading documents on that. You know, parties can further argue their case, and we can discuss further later if the Commission wants to. But in order to take new evidence, essentially a party has to show good cause, and then if the Commission determines good cause has been shown and wants to remand it back to ALJ for additional proceedings, the Commission may do that. Conduct of the oral argument. The Commission's policy is allow each side to make 15 minutes of oral argument, followed by 5 minutes for rebuttal. The Commission may ask questions at any point. The Commission will then close the oral arguments and deliberate towards a decision. I am available to assist the Commission in its deliberations and or implementing any of its, you know, desired outcomes. The respondent should proceed first here because they're the ones that filed for review. And that is all I have. If the Commission has any questions on any of that, go ahead. Otherwise, the respondent, I'd ask the chair to direct the respondent to begin oral argument.
Okay, Commissioners, do you have any further questions on process or what Gary has summarized for us? Otherwise, if we don't, we will just proceed with hearing the arguments.
I do have one question.
Commissioner Addington.
Gary, I think I understood the last part. When we deliberate, is it all on the record in public? Is there an opportunity for the Commission to deliberate either amongst themselves in executive session or with you if we have questions?
So it has been Commission practice, and I understand, to do all deliberations in open session. There would be an opportunity if the commission has legal questions or wants legal advice or something like that to get legal advice from me, and that could be done in an executive session. There are also opportunities in some situations, I believe, to deliberate under contested cases in executive session. It has not been the commission's practice to do that. But if there are, if there are issues that the commission feels it needs to discuss in executive session, or is not comfortable making a decision without further legal advice on things, we can discuss ways of doing that, I think, during deliberations. Does that answer your question?
Yeah, it's helpful. Thank you.
Okay. Any other questions before we get underway with the presentation of the arguments? Okay, hearing none. Go ahead, representative for Northwest Metals, go ahead and start with your arguments. We'll have 15 minutes for that, and then we'll proceed with DEQ presenting its arguments. Please go ahead. Oh, and the opportunity for rebuttals, as was stated.
Okay, thank you so much. This is Adam Kimmel, lawyer for Northwest Metals. Can everybody hear me all right?
We hear you very well.
Great, thank you so much. Mr. Vrooman, I think what he said is completely right as far as the facts go. I didn't hear clearly that he said that either the council, that the Northwest Metals was or was not represented by counsel at the hearing in front of Judge Fair. In fact, I did not attend that, and Mr. Anata, the principal of the company, handled that himself personally. I did just an hour ago, half an hour ago, file a paper asking that the matter, that the commission consider remanding part of the case back to the administrative law judge. With your permission, I'll wait to talk about that until later. I'm concerned that 15 minutes can fly by very quickly, and I won't get to make the substantive points I wanted to make. So, as I understand, I have the 15 minutes, and then after that, some 5 minutes, and if need be, we can talk about this recently filed request for remand later. Is that all right? Yes, okay.
Gary, so a procedural question. This gentleman wants to know if there's additional time to talk about this new request that apparently was received while we were in the commission meeting. So I just want to pause, and I want to be sure that we treat that appropriately in regard to procedure.
So the short answer is it's in the commission's discretion to do what it wants. Practice has been to do 15 minutes and 5 minutes. A lot of times, that is followed by some commission discussion and questions to the parties if they view that as being necessary. If the chair and the commission would like to grant more time, you're entitled to do that.
All right, thank you. So, sir, what we would, I think, do is let you get on with your substantive remarks, and then perhaps, do that. I think, you are aware that we have received all the materials in advance as well. And then let's spend perhaps a few minutes towards the end of your remarks. You could give us a little bit more specifics on the recently submitted request. Does that work for you?
Perfectly. Thank you so much.
Okay, very well. Go ahead.
Great. Okay, so the company filed a brief, a 15-page brief at the end of last September. And then DEQ responded, and to that I replied in February. And the reply is a shorter document. And I understand that you have those. In my statement here, I'm going to follow the order in which I address things in the reply. That's the shorter document that I filed in February. The first thing I was hoping to talk about is the matter of whether the company violated the rule by having too many waste tires on site. That's allegation number 4. The ALJ, Judge Fair, ascribed a total penalty of $7,600 for that. I don't think that the company should have to pay that. There's two reasons. One is that there's a clear, relatively clear anyway, definition of what is or is not a waste tire. In the DEQ regulations, that's found at 340-064-0015, subpart 33. And it says a waste tire is a tire that's no longer usable as a tire. You know, it could be made into sandals or melted down for something else, but it doesn't work as a tire anymore. And it's a straightforward sort of definition that depends upon the physical properties of the tire. Northwest Metals is taking, you know, when it's operating, hundreds of tires off cars every day. And most of them are not waste tires. There's still some good tread in them. There was evidence in the case that some 4,700 non-waste, still usable tires were sold by the company over the year and a half or so preceding the ALJ hearing in May of last year. And some 1,700 1,700 waste tires were on top of those 4,700 non-waste tires were disposed by the company. And that included tires burned in the fire, but not just tires. This is, again, I mean, just not burned tires. It was over a period of some year and a half, and the tires are constantly moving in and out. So there's a relatively straightforward definition of what is a waste tire, and it depends only on the physical properties of the tire. It doesn't matter how the tires are stored. I mean, it does matter how they're stored, but in terms of whether it's a waste tire or not, it doesn't matter. Now, the regulation says that a wrecking yard company or a tire reseller, this is a different regulation. This is 340-064. I'm sorry, it's the same 0015. And I'm sorry, you know, the definition that I gave, the section number I gave wrong. For the definition of the waste tire, it's 340-064-0010. In 0015 of the same set of regulations, it says that a company like ours is allowed to have up to 1,500 waste tires on site. Now, I don't know really what's magic about why the limitation is just for waste tires, but it does not, the limitation does not apply to non-waste tires, still usable used tires or new tires for that matter. So the ALJ decided, and I think for a reason that was outside the evidence and was just plain wrong, that these tires were at least predominantly waste tires. And the reason that she gave was that they were not stored in sets of 4 or 5 tires in an organized way. And she said it would be impossible. And this is not based on evidence, but I guess her own idea of how tires work, and I suspect that she just didn't really know so much about tires. I think she's probably one of those people who buys tires in sets at Les Schwab or someplace like that. But there's a completely different market for tires where one tire wears out and they just replace one tire. And instead of paying $100 at Les Schwab, they pay $15, $20. So for it to be a usable tire and for it to be saleable, which the company does, it doesn't have to be in a set of 4 or 5 tires. It doesn't have to be neatly piled up. And in terms of identifying a tire, every tire has embossed in the rubber of the tire its dimensions. There's numbers that say how big it is, what its properties are. So it's a perfectly saleable, used, functional tire. It's not a waste tire, and it doesn't matter if it's stored in a messy way. I talked about that in my brief. The second thing is that the administrative law judge agreed that a particular regulation that deals with waste tires generated in Oregon, that's 340-064-001034, somehow makes all tires removed by a wrecking business into waste tires. But the problem with that is that that's reading this regulation completely out of context. Number one, Part 34 completely contradicts Part 33, which says that the waste tire has to be a tire that's no longer functional as a tire. And 34 is designed to show which tires qualify for a special program that's managed by DEQ, where people are subsidized, given money for storing waste tires, but it was never intended to make a fully functional tire a, quote, waste tire, in contradiction to the definition in 33. And it's such a roundabout, kind of crazy way of saying it. I'd also urge, I'm taking too long to talk about this, please take a look at the full text of the definition of this page, of this Part 34 in 340-064-0010. You'll see in all of the versions, all the papers in front of you, that everybody took out the Part A, Subpart A of the 34 definition, which talks about tire resellers. When you consider that, I think you'll see that it's just crazy to apply this Part 34 to say that all of these tires are therefore waste tires. What that really does is completely change the 1500 limitation. Instead of it being just waste tires, it now becomes all tires, or at least all tires removed from a vehicle, whether they're waste or not. I think in that respect, the ALJ missed the calling, misconstrues the law, clearly wrong, and relied on evidence that's not there to arrive at a result that's not correct. Number two, I wanted to ask if you would reconsider the penalty assigned for the failure to obtain an ACDP permit. That's number 6. The amount is $10,165. That includes the base penalty, mitigation add-ons, as well as the cost, economic benefit of some $5,000 that was saved by not applying for the permit. Our argument is set forth again in the original brief and in the reply. The idea is that we're way below the limit, and that the regulations require that DEQ take into account controllable limitations. The language in subpart 85 is arguably ambiguous, but when you compare that to the definition of potential to emit in 340-200-0020-124, that clearly says that DEQ must consider the lesser of the full, 24-hour, 7-day a week, 52 weeks a year, 8,700 and whatever it is, 60 hours. The lesser of that, or the amount of emissions that would be produced, quote, taking into account, unquote, limitations. And there's no reason why there could not, and the company offered to enter into an agreement to limit its usage. That would be a fully enforceable limitation. The definition, again, specifically looks into that. Now, I'll talk more in connection with the motion that I just made about the ACDP permit. But I think on the law, it's clear that DEQ is ignoring its own regulations in insisting on this. 3 is, I wanted to tell you that I thought also that the $6,600 penalty assigned for in case number 2, the one that talks about placing wastes where they're likely to enter groundwater, is not supported by the evidence. In fact, there's clear evidence otherwise. The evidence was only that it's possible as opposed to likely, that the contaminants that the company is accused of putting on the ground would make their way to groundwater. The statute says that it must be shown that it's likely to enter groundwater. That's ORS 468B.0251. In this case, there was not that sort of evidence. An additional reason not to charge this $6,600 is that it's really double punishment for the same thing. The first allegation against us, which is doing various sorts of industrial processes in an area where there's UICs, is again to protect the groundwater. Both cases, if you go through the evidence and the ALJ's decision, basically cover the same ground. This is two ways of punishing us for the same thing. You know, this is done in criminal law, where everybody gets charged with every crime and lesser included crime that the conduct constitutes, but it's still double punishment. And when sentences are handed out, people don't get, generally, criminals that is, generally don't get punished twice for the same thing. The sentences are made consecutive. And I think it's the same sort of thing here. For the one that we're not challenging here, we were assessed a penalty of $14,400. On top of that, to add $6,600 is unfair and wrong. If you would, I'll be very fast on the rest. I ask that you consider the additional amounts that are ascribed against the company in respect of its purported mental state. I discussed that, and I have the numbers on page 6 of my reply brief that was filed in February. The base penalty here was $23,750. Added to that is another $29,000 for aggravating factors. The aggravating factors are set forth in the Administrative Law Judge's decision on beginning around page 42. That pretty much copies the text. One of the things is that that DEQ ascribed in the ALJ allowed against the company penalties based on a mental factor of 8, which is not the most, it could be 10, but 8 is if the conduct were reckless or they acted intentionally with actual knowledge to disobey the law. I think that's altogether inappropriate in this circumstance. The company is, I think, fairly charged with a 2, which is in respect of what is called constructive knowledge. They should have known about the requirements but didn't know about them. And that seems much more appropriate here. This in between 2 and 8 is 4 for negligent behavior. There's a definition of reckless behavior, and it requires that the respondent, in this case the company, consciously disregard a substantial and unjustifiable risk. It's like shooting off a gun when there's a lot of people around. You don't intend to kill anybody, but you really don't care. And you shoot it off, and that would be reckless behavior and conscious disregard. That's not what the company did here. And the fact that in a few circumstances, like for the permit and for the tires, that DEQ told the company that they thought the company was wrong. The company always said back, we disagree on the law, we think we're justified. Even though they know about it, that doesn't make it reckless. That makes it a good faith, honest dispute about what the law means.
Thank you, Mr. Kimmel. That's 15 minutes. Would you like to speak to the other issue that you've raised and you've said you want to be sure that we understand?
Thank you so much. I'm happy to do that, and thank you for listening. And I'm sorry to have gone over time. Okay. Since May of last year, the company there's been continuing litigation between DEQ and the company, which is more or less mostly resolved at this point. And Ms. Brown will know all about this as well. One of the things the company did agreed to do and did is in February and March, it submitted an application for that ACDP, the air pollution permit, and it paid the fees for it. And since then, DEQ has been, processing the application. I've been talking with a fellow named Timothy Smith, who works for the Department of Justice and representing DEQ on this matter. And yesterday he told me, just yesterday afternoon, it was absolutely the first time I heard this. And I'm not blaming DEQ. They apparently came to this thinking just recently themselves. But what I heard from Mr. Smith is that DEQ is considering whether the air pollution permit application of the companies must be reconsidered in light of not only the ordinary processing for permits under Division 216 of the DEQ regulations, but also under a special program called the Cleaner Air Oregon program under Division 245, which looks for the emission. As I understand it, I didn't know anything about it until after I spoke with Mr. Smith. I looked at it a little bit last night at the regulations, and it appears that it requires all sorts of investigation and testing for the possibility of creation of cancer-causing or other kinds of toxic chemicals. It appears that there's something like 400 or more kinds of chemicals that have to be considered. It sounds like a huge deal. And I'm not saying there's anything wrong about DEQ coming up with this at this point, although there were in many discussions before that, it was never mentioned. But, if I knew more about immigration law, I might have foreseen it. On immigration law, I meant environmental law. In any event, it appears to me that it's entirely likely that the company will not, in fact, qualify for a permit under this new sort of review. And my notion is that it's grotesque. It just strikes me as extraordinarily unfair for the company to be penalized some $10,000, including the economic benefit, for not applying for a permit that, in fact, now that they've applied for, they're not going to qualify for. And I understand from Mr. Smith that DEQ at this point doesn't know how long it's going to take to complete this kind of review, even to determine whether or not this Cleaner Air Oregon program applies or not. What I'm told is that the company is, in this context, the first of several people in the city in Portland who operate these shredding machines with automobiles, and that it has to be considered on an industry-wide basis, so that there's two competitors that also have to be brought into the picture. And so there's a first round of thinking to see if the program applies, and then secondly to figure out how the company would qualify. This may take months. I asked Mr. Smith, and he told me he had no idea how long it would take. Again, Ms. Brown may very well know more about this than I heard from Mr. Smith. But in any event, my notion is that the only person who can really, without uncertainty and the real possibility, it seems to me, that the company would not qualify, that this matter should be reconsidered about that $10,165, and the only person who can do that, it seems to me, is the administrative law judge. And therefore, at least part of the case should be sent back to the administrative law judge for her, at an appropriate time when we know more information, to take additional evidence on whether it's appropriate to charge the company. Again, the $10,165 is in two parts. One part is a penalty for not doing it, but the second part is the economic benefit that the company obtained by not applying for the permit. And I'm thinking at least the economic benefit is wholly inappropriate in a circumstance where the company could not qualify for the permit in the first place under these rules. Okay, thank you very much.
Thank you, Mr. Kimmel. Okay, the DEQ rebuttal.
Chair George and Commissioners, good afternoon. For the record, my name is Kieran O'Donnell, and I'm the manager of DEQ's Office of Compliance and Enforcement. And I'm here today with Courtney Brown, an environmental law specialist with DEQ's Office of Compliance and Enforcement, and we are here to present DEQ's position in this matter, requesting that the Commission uphold the administrative law judge's proposed order. So without further delay, I will turn it over to Ms. Brown for DEQ's oral argument.
Ms. Brown, we cannot hear you. You are still muted.
Can you hear me now?
Yes.
Thank you. Sorry about that. Commissioners, as Karen mentioned, we are here today to ask the Commission to uphold in its entirety the decision of the Administrative Law Judge, Samantha Fair. Judge Fair presided over 3 full days of a contested hearing, a hearing that included the testimony of 9 witnesses and almost 100 exhibits. And her decision is 54 pages long and includes over 74 findings of fact. Her findings are well supported by the evidence and the testimony presented at the hearings, and her conclusions of law are correct and appropriate. DEQ believes she was thoughtful and careful and faithfully executed her duties in an impartial and unbiased manner. I'm gonna go over some of the background, and then I'm gonna delve into the issues that Northwest Metals contests most strongly in its briefing. I would like to quickly address the late filed motion that Mr. Kimmel closed with in his oral argument. And I'd like to say that as Gary Vrooman pointed out, a motion like the one he filed is required under the administrative rules to accompany their briefing to the EQC. And obviously this one did not, since it was filed yesterday afternoon. Also, the model rules governing contested cases require the opposing counsel confer in good faith with DEQ before filing such a motion. And I heard nothing of it until he emailed it to me 20 minutes before this oral argument. I think if he had conferred with me, we might have had a productive discussion about some of the issues that he raises. Lastly, I'd like to say that the administrative record before Administrative Law Judge Fair closed a long time ago. Almost a year ago was when we held the contested case hearing. And the matters that she deliberated on occurred well before that. What is happening now with DEQ's drafting and consideration of Northwest Metals air permit is completely irrelevant to the contested case that is before you today. I don't think his motion raises any new factual issues, only to say that you know, it's possible that it's going to take DEQ longer and to issue the permit, and that permit will be more complicated and expensive. But it has nothing to do with the issue of Northwest Metals liability under the air permitting rules, and that's the issue that's before you today. So as you know, Northwest Metals was the site of a catastrophic fire in March of 2018. It operates an auto dismantling and salvage business, which means it takes in junked cars, removes their fluids and their residue, that is the upholstery, the foam, the plastic, the vinyl, and then shreds the car husks and sells the metal. So in addition to these junked car husks, Northwest Metals also accumulates a lot of this vehicle residue, the foams, the plastics. And when the fire occurred, all of that combusted and was released into the air, and also deposited onto the ground. So it was the combustion of these materials which released all these hazardous substances into the air that brought DEQ to the site after the fire. The nature of the auto salvage business poses a high risk of harm to human health and the environment under the best of circumstances. So it is imperative that a business like Northwest Metals comply with rules which are designed to prevent the harm that auto dismantling and salvage may cause. In our post-fire investigations, DEQ discovered site conditions which continued to pose a threat of environmental harm and public health and exacerbate the risk of another fire. Shortly after the fire, we issued a removal action order, also known as an RAO, which required Northwest Metals to do a comprehensive assessment of the site and remove fire debris. And our staff spent months after the fire working with Northwest Metals and providing technical assistance to help it to implement the RAO and clean up the site and do the other things it needed to do to mitigate some of the hazards. By the end of
Ms. Brown, it's just a brief interruption here to just say the 5 minutes we had for rebuttal has concluded. It's just a minor pause because it is indeed now your time for 15 minutes worth of arguments. So please continue.
Oh, I beg your pardon. I thought that I was already into my 15-minute argument.
Well, so we certainly got a good 5 minutes of that. So if you want to, add any rebuttal to the end of this portion, you're welcome to do that. We will not short you on time. You have an additional full 15 minutes.
Okay. Well, I guess I would like to reserve 5 minutes of my 15 minutes to rebut Northwest Metals.
I think I just said that unclearly, so I apologize. Yes, if it works for you, what we'll do with is another 10 minutes of your presenting your case, and then you can essentially get the 5 back for the rebuttal. Does that make sense?
Yes, I think so. Thank you.
Okay, good. I apologize for not being quite as clear about the time frame. I'll be sure to make that additionally clear. Please continue.
Okay, so I'm going to jump into the violations that Mr. Kimmel discussed. First, the violations related to the UICs and placing waste. DEQ alleged and Judge Fair agreed that Northwest Metals is liable for the violation of operating a prohibited UIC. And so what that means is a UIC is allowed if it injects only stormwater from residential, commercial, or industrial facilities that have not been exposed to hazardous substances, toxic materials, or petroleum products. The UICs at the Northwest Metals facility are prohibited, we alleged, because Northwest Metals uses hazardous substances, petroleum products, and toxic materials in a manner that exposes them to stormwater, and when it rains, the stormwater mixes with these hazardous materials and it gets into the UICs. And it's on that basis that they are prohibited. And this was based on evidence at the hearing of Northwest Metals' sloppy housekeeping. They had broken barrels of petroleum with no lids, some with broken lids, and throughout the facility there was evidence that petroleum had spilled to the ground, the soil was stained, and there was no effort to clean it up. If Northwest Metals would employ best management practices to contain these materials and prevent their exposure from stormwater, their UICs might not be prohibited. But sampling of the UICs showed that a lot of these vehicle fluids actually made it into the sludge and the soil, the sludge and the water inside the UICs. So we know that these toxic materials actually were injected into the UICs, and they are therefore prohibited. We also alleged a violation of placing waste in a location where they're likely to enter waters of the state. and in this case it was groundwater. This is because these hazardous substances were actually found in the soil underneath the UICs, and we know that groundwater in the area is 52 feet below the ground surface, and surface water, the Columbia Slough, is 2,000 feet away. So I disagree with Mr. Kimmel's assertion that we are that it's double punishment for the same conduct. It's possible for them to operate the UICs and engage their industrial practices in a way that this stuff doesn't discharge into them, and they simply didn't do that. So DEQ cited Northwest Metals for 2 violations related to its accumulation of tires at its site. At the time we issued our enforcement action, DEQ rules required a waste tire storage permit for a facility that stores more than 1,500 waste tires. After the fire, DEQ performed many inspections of the site to count the tires to determine if the permit was needed. Our inspector estimated that there were well over 1,500 waste tires at the site, and Administrative Law Judge Fair's order includes many findings of fact that state that there were well over 1,500 waste tires at the facility. The determination that all these tires were waste tires as opposed to any tire that could be resold was also informed by the fact of how these tires were stored at Northwest Metals. There were numerous findings of fact about the haphazard manner in the way in which these tires were jumbled up in huge piles, mixed in with the auto residue and the metal that was waiting to be shredded and recycled, and piled adjacent to buildings, and many piles even had blackberry vines growing through them, and they were not stored in any manner where one could even read the markings on the tire to determine if it was of a size that a prospective buyer might want, let alone access the tires to retrieve them for a prospective buyer. Our other violation related to the waste tires was that the way in which they were stored violated the DEQ rules regarding standards for waste tire storage sites. So the rules say that even if you don't meet the 1,500 permitting threshold, you still need to store the tires in a manner that mitigates their fire hazard. During the hearing, DEQ's solid waste inspector testified how tires are notoriously flammable and once ignited are very difficult to extinguish. And so the standards for waste tire storage sites require things like fire lanes, requires that tires be stored at least 60 feet from a building, and places limitations on the dimensions of the tires. And Northwest Metals did not comply with any of these requirements, even in the months after DEQ started to alert them to these violations. Moving on to the air permitting issue. Northwest Metals has used an air shredder since March 2018 when this fire occurred. And DEQ rules require that if a source like a shredder emits certain pollutants above 10 tons per year when the shredder is operating, quote, uncontrolled, that it requires a permit. So DEQ interprets the operate uncontrolled language to mean if the source operates to mean operating 24 hours a day, 7 days a week, 365 days a year. That is how DEQ determines if the permitting threshold has been triggered. They look at the total potential of the source's emissions. In DEQ's interpretation of its rules, the only way to control operations is to place an enforceable limitation via a permit. So Northwest Metals argues that it doesn't even use its shredder very much because it breaks down a lot, and that it certainly uses it less than 24 hours a day. And that DEQ should enter into an agreement with it, where that agreement could be the limitation or the control on its operations, and that DEQ could enforce that agreement if we needed to by bringing a lawsuit against Northwest Metals. It also says that a letter that DEQ sent Northwest Metals agreeing to allow it to use the shredder for a short period of time so that it could remove fire debris from the site and comply with the REO, that letter should be considered a limitation. But again, the letter, a potential agreement, are not limitations according to DEQ's rules, and to allow Northwest Metals to avoid getting the ACDP permit on these bases would be to treat it differently than we've treat other sources, and to carve out an exception for Northwest Metals. Lastly, I'll discuss the violation related to the removal action order that we issued just a few weeks after the fire. As I mentioned, the goal of the REO was to compel a full assessment of contamination at the site, and it included deadlines that were triggered by DEQ's approval of the development of a work plan. It said, for instance, that fire debris removal must be completed within 5 days of DEQ approval of the work plan. DEQ gave final approval of the Northwest Metals work plan on July 12th, which would make fire debris, July 12th of 2018, which would make removal of fire debris due July 17th. Northwest Metals didn't comply with this deadline in the REO, and it didn't comply with most of the deadlines in the REO. And throughout the summer of 2018 and even into the fall, DEQ gave multiple extensions and accommodations to Northwest Metals and gave it the benefit of the doubt that it was operating in good faith to fulfill its obligations under the law. It eventually became clear to DEQ that Northwest Metals had returned to business as usual and was continuing to accept the junked vehicles on site and process them for scrap. And doing so hindered its ability to clear the site of fire debris and to complete the comprehensive assessment of the contamination at the site. It was simply accumulating so much stuff on site that no one could access the soil beneath it to conduct the necessary sampling. Administrative Law Judge Fair found that Northwest Metals, quote, prioritized its ongoing business operations over compliance with the REO, and that it preferred to continue to accumulate more vehicle husks and scrap, which inhibited its ability to clear the scrapyard for fire debris removal and sampling. I'll just conclude by saying that the hearing was 3 full days. Some of them were more than 8-hour days. The administrative record is full and complete. And Judge Fair heard from all of DEQ's witnesses and from Mr. Anata himself, the principal of Northwest Metals. She weighed their credibility and asked them questions and examined the evidence and found in DEQ's favor on every single element of all of the violations we alleged, and the judge's orders should be upheld. Thank you very much.
Thank you, Ms. Brown. And I apologize for my time management mistake. I had made a mistake there, and so I thought, in fairness to, we allowed Mr. Kimmel an additional 5 minutes to address his issue, so I allowed you an additional couple of minutes as well, since I had interrupted your presentation, and it was my mistake on time management. As we can see right here on our slide, now both cases have been presented. And so now is the time for rebuttals. And once again, Northwest Metals is up first with an additional 5 minutes for rebuttal. So the floor is yours, Mr. Kimmel.
Thank you so much. Okay, you know, when I talked before, I just talked really about 4 things. I talked about the tires, which is number 4 of the 7 allegations. I talked about the air pollution permit, which is number 6, and I talked about whether it was appropriate with respect to number 2 about the placing wastes where they could get to groundwater. And then I talked about mental state matters. I didn't mean to imply that Northwest Metals agreed that it was responsible and that the penalty assessed against it for the other matters were, you know, appropriate. I made arguments in the first brief that I filed late September against the other ones. And I'll just have to rest on those for the most part. I did want to make just a few points. With respect to number 1, which was, again, the hazardous substances being used in an area near the UICs. There was evidence, and I talked about it in the, I'm sorry. I think that of the 14,400 that's assessed for that, while I might not have assessed it were I Samantha Fair, I can understand her decision about that, except for the part about the mental element of it, which makes up a total of the aggravating factors, 8,400 out of the 14,400. There was evidence uncontradicted that before the company started operations at all on the site that they got in touch with environmental authorities, that they had discussions with someone deputized by this, I think it's the city of Portland or the Multnomah County, I don't remember which, but they investigated, they talked with these people and were told that there were no you know, particular problems, and were told that there were no UICs. They didn't know that there were UICs there. Now, maybe they should have known, maybe they should have investigated better, but to say that they knew about it and deliberately, consciously disregarded the risks is really entirely unsupported by the evidence and ignores this evidence. So, if number 1, if that's to stand for the company, that should be just the $6,000 or some 6,000 plus a factor of 2 rather than 8, which would add another 1,200 to the 6,000. With respect to the wastes, all right, number 2 is covered enough. We don't have time for it. But there was testimony over and over that from DEQ people that it was possible that chemicals could work their way down through the soil to groundwater, but never that it was likely that that would happen. And that's what the statute requires. And also, DEQ's person stated that he had not even looked at evidence that was in the record of reports showing contamination at exactly the same site in 2013, before Northwest Metals even started at the site. Okay, with respect to the tires, the DEQ person who came out to count tires admitted that he made no effort to distinguish waste tires from used tires. His count was of all tires. Again, you know, there was also uncontradicted evidence that there were more than 4,700 used, non-waste, usable, suitable tires sold by the company during the year and a half or so preceding the hearing in front of the judge. So the company is all the time selling non-waste tires. as well as disposing of waste tires at a different, to different people, and a much smaller number. With respect to storing the tires properly, in my first brief, I have these kind of what I guess called kind of technical, legalistic kinds of arguments. I think they're valid, but on the other hand, I can understand that the penalty for storing these tires in a messy way is not entirely inappropriate, and it, of course, did create a fire risk. That's probably the least objectionable part of what the administrative law judge did. Returning to the air pollution permit, this uncontrolled language in Part 85, where it says that you figure, I'm sorry, let me just find that. It talks about 85, talks about how sources have to be permitted if the source were to operate uncontrolled and produce more than 10, whatever it is, tons. It's really ambiguous language. That it may mean, just as DEQ says, that you just do not consider any controlling limitation, or it means that the full 24-hour or 7-day a week, 52 weeks a year, 8,000 hours calculations apply only if there is no control.
Thank you, Mr. Kimmel. That's your time for rebuttal.
Thank you so much.
Ms. Brown, you also have 5 minutes for rebuttal.
To Mr. Kimmel's point that Northwest Metals didn't know the UICs were there because some official with the county or otherwise told them something, I would urge the commission to look at the orders finding of fact number 17. It talks about the City of Portland's Bureau of Environmental Services having done an inspection. They were not there to look at the UICs, but that finding of fact talks about how the UICs are plainly visible and were plainly visible to Northwest Metals. They have a riser on them with a cap, much like a sewer manhole. And so Northwest Metals would have seen that there was potentially a discharge to the storm sewer at the site. Nonetheless, they covered them up with the vehicle husks and the residue and the other scrap at the facility and failed to take any precautions to protect them whatsoever. All of the contaminants in the UICs are attributable to Northwest Metals operations. Mr. Kimmel mentioned something from an assessment in 2013 that was conducted by the previous property owner. And in addition, they fully cleaned out all of the UICs, did all of the sampling, so they were clean and got a clean bill of health and were registered with DEQ to prepare them for sale to the current property owner, which is Northwest Metals landlord. So those UICs were totally clean. We know now that they are contaminated, but they had been fully cleaned out. About the likelihood of contamination migrating to groundwater, DEQ's senior hydrogeologist testified at the hearing that if not remediated, the contamination in the soil below the UICs at Northwest Metals will continue to migrate to groundwater. Continuing to do an assessment down to the aquifer is actually a requirement of the RAO, and it hasn't been complied with yet. About the mental state, the aggravating factor that DEQ alleged Northwest Metals was reckless in its conduct for almost all of the violations that we alleged. The definition of reckless means that the respondent consciously disregarded a substantial and unjustifiable risk the result would occur. For every single one of the violations that DEQ alleged, DEQ sent warning letters, emails, letters, had face-to-face conversations with Mr. Anata. We told him what the law was and told him what he needed to do to comply with it before we ever issued the formal enforcement action. We have a policy of escalating enforcement and soliciting voluntary compliance from regulated entities, and we did that with Mr. Anata and with Northwest Metals in the months leading up to the issuance of our formal enforcement action. So the M factor, alleging that he was reckless in continuing to disregard the law, I think is very appropriate in this situation and with respect to the violations where we alleged he was reckless. That's all. Thank you.
Okay, thank you. Well, both rebuttals have been made. Now is our time for a commissioner discussion, the asking of clarifying questions. So we'll go ahead and open the floor. And if folks have questions or comments, commissioners, please share them now. Yes, Commissioner Mosby.
Yes, this is for Mr. Kimmel. Mr. Kimmel, in the presentation earlier of the written stuff, it said that Mr. Anata also had a tire shop on a separate location that he started in 2017. What kind of storage did he have at that tire shop? Why wouldn't he have stored used tires for resale at his tire location rather than at a scrap location?
Sir, he does store tires. He still has that shop on 148th to sell tires. They also sell some vehicles there. He does store tires there, but there's limited space available there. So the tires are constantly being moved from the Killingsworth location, where they're taken off cars that are being scrapped and sent over to the 148th location. Before the fire took place, the company's plan was to open additional tire retail selling locations besides the one on 148th, so that there could be enough sales to use up the tires that were being taken off vehicles. But those additional shops, the fire was a complete financial disaster, and we have not, as well as environmental catastrophe for people in the neighborhood. And the company has not been able to go forward with those additional shops.
Thank you. Other questions or items for discussion, commissioners? Commissioner Barrasso.
This is for Mr. Kimmel. You noted in the opening argument that there were, of the 40-something hundred tires that were for sale, you said there's 1,700 tires that were waste tires? I just wanted to make sure I heard that correctly.
Yes, exactly right. I think the evidence, it was given by, there was one DEQ, I'm sorry, I'll back up. Before the hearing in front of Judge Fair, the company supplied records to DEQ of both of its sales of non-waste usable tires and also of its disposal of waste tires from the from the Killingsworth facility. I don't remember exactly, but I believe that those records went back to the beginning of 2018. I could be wrong. It could have been a little back to the fire in March rather than the beginning of 2018, and continued until more or less the time of the hearing. And I think the numbers were something like 4,700 for non-waste usable tires that were sold to various tire wholesalers. On top of that 4,700, there were tires that were shipped over to 148th. I don't believe that was included in the 4,700, although it could have been. It's a somewhat smaller number than were sold to wholesalers. And then on top of that, there were something like 1,700 waste tires that were sent, and many of them had been burned in the fire, that were sent to people who dispose of whatever's left of tires when they're no longer serviceable as tires. And those numbers came from the DEQ representative who had actually counted up the papers that Northwest Metals had supplied to DEQ.
Commissioner, may I add some additional information? In the proposed and final order of the Administrative Law Judge, finding of fact number 73 talks about these numbers and which ones went to the used tire recycler and which ones were sold. We did have a DEQ person count up all of the information, the receipts and things that Northwest Metals provided to us. And those totals are 4,736 used tires went to recyclers between January 2017 and March 2019. And there's some other numbers in there, but it's all summarized in that finding of fact.
Thank you. All right, commissioners, other questions, comments? Commissioner Addington.
For Ms. Brown, I wanted to ask about the unpermitted use of the shredding machine and this standard of operate uncontrolled. If I understood you right, so this is the standard that's used for anyone who's operating a shredder or something like this. It's how much it could produce if it ran all the time, 365 days a year. Whether I like that or think that's appropriate, or whether that's the standard that's used for everyone. Is that correct?
That's correct. It's based on the total potential to emit.
And that's not, is that well known? I mean, in an operation like this, are these things that DEQ talks about with the operators?
I believe so. I don't write the permits and I don't interface with the with those sources, but I do think that I don't think this was something that DEQ just started to do for Northwest Metals. It's written in the rule that that is how we calculate what the potential emissions of an air source will be.
That's fine, thank you.
Did you have anything else, Commissioner Addington?
No.
Okay.
Well, Madam Chair, I actually do have one more. Also, Ms. Brown, on the same issue, just could you just talk for a minute about the magnitude of the violations, and I was trying to understand some of that about moderate versus major or minor and how that comes about. Things start at moderate, is that right?
Yes, in calculating the civil penalty, we follow our civil penalty formula, and part of that formula is an assessment of the magnitude of the violation. That's meant to capture the environmental impact of the violation. And if we don't have evidence to show that the violation had a major or a minor or de minimis impact, then we go with the default of, which is the moderate magnitude. And I think the majority of our violations end up being moderate magnitude because we often don't have the kind of evidence to show that something was de minimis. When you're dealing with toxic air emissions and cancer-causing materials that have gotten into the air, and there's people who live right next door, we didn't have evidence to show that these violations, particularly the air emissions, would only have a de minimis impact. At this point, it's an unknown. And so we go with the default, the moderate magnitude.
Thank you.
All right, commissioners, any last questions? Okay, hearing none. Commissioners, we're going to open the floor to some discussion. If folks have something in mind that they wish to discuss with other commissioners. And also earlier, there was an inquiry about, if there was any questions about legal advice or matters of law, we could also ask questions of Mr. Vrooman. So we'll open the floor to entertain any discussion of that nature to proceed with our case. Okay. Well, hearing none, Mr. Vrooman summarized as we got started the various actions that the EQC may take. And they are, of course, limited by the Commission's authority, but put simply, the Commission may issue a final order adopting the judge's proposed and final order, or they may issue a final order determining that the findings of fact were not based on the preponderance of the evidence. And under those circumstances, the Commission must explain why and amend the proposed and final order accordingly, or take other actions within the Commission's authority. And Mr. Vrooman spent some time discussing that as well. Are there any commissioners who would like to make a proposal for the discussion of the group about the EQC's decision action in this contested case?
Chair, if I might, this is
Yes.
This is Council Gabriel. Just to clarify, what you said was generally correct. There's essentially three basic actions the EQC can take: adopt the final order, modify the order, or remand it back to the ALJ. If you want to modify the order, it can be a little bit complicated how you do that and when you can do that. There's factual and legal issues. If the desire is to make modifications, maybe we can talk more about that. But those are basically the three options: adopt the pros option order, modify the order and issue a different order, or remand it back to the ALJ for further proceedings. And there's sidebars around what can be done with the ALJ too. So that's my summary.
Thank you. That's a much more precise summary than the one I offered from the end of our posted materials. And if we proceed with an action like that, then I suspect we will be working with you to make sure that we would provide what is needed. All right, well, commissioners, hearing no proposals, I am going to proceed as we did last time with simply starting with the simplest of the proposals to see if there is support for that action, and we will proceed as necessary. So commissioners, could you please let me know if you would be in support of adopting Judge Fair's proposed and final order as written?
This is Commissioner Kyle. I would be.
Thank you, Commissioner.
Commissioner Mosby, I would affirm Judge's order.
Thank you.
I would Commissioner Barrasso, likewise, I would affirm.
Thank you, Commissioner.
Yeah, and I just want to say this is not my favorite part of this job, and it's, there is just a ton of information here, and a lot of time, and I did my best to go through all of it. I just find myself, jotting a few questions here and there, but landing ultimately where the administrative law judge did as well. So I'm in that same camp.
Thank you, Commissioner, as am I. So with that, I would entertain an order, I would entertain a motion for the EQC to act in support of adopting Judge Fair's proposed and final order.
I'll make a motion. I don't know, Gary, if this is right, but you tell me. I'll move to that the Environmental Quality Commission uphold ALJ, Administrative Law Judge Affairs final order.
Sufficient?
I think that'll work, yes.
Do we have a second?
Second.
I'll second, yeah.
Motion's been made and seconded. We will have a roll call vote. Those in favor, please signify by saying aye. Commissioner Barrasso?
Aye.
Commissioner Kyle?
Aye.
Commissioner Addington?
Aye.
Commissioner Mosby?
Aye.
The motion passes. I want to thank everybody for your time today and the tremendous amount of work that went into this. Thank you, everyone. Okay. So having concluded with the contested case hearing, we need to move on to our public forum, and instructions and process for presenting comment has been provided in advance. But Stephanie, do you want to give us any notes as we start moving in to the public forum?
Yes, thank you, Chair George. This is Stephanie Caldera, Assistant to the Environmental Quality Commission. On the displayed screen through the Zoom app, people should see those sign-up directions that were posted previously online. For folks who are connected through the Zoom app, if they want to indicate a request to get into the speaker's queue, I ask that you now click the yes green check mark. It may also show up as raise hand, depending on which platform or which version of the platform you're using. If you are connected only by telephone, I ask that at this time you press *9, which is the same action for raising hand. And I am seeing that people are entering that. I will need just a moment, Chair George, to tally the total group, and then we'll check back in and we can move through public forum at that time.
Okay, thank you.
Thank you all for your patience. This is Stephanie Caldera, EQC Assistant. At this time on my screen, I am showing a total of 9 people who have indicated to either raise their hands or the check mark, so thank you. And we will go through those first 9 as we go one by one. Chair George, with your permission, I will unmute the lines individually of the folks. And as they begin, I ask that they state their name for the record. We will go through these first 9, Chair George, and then I'll make sure I haven't missed anyone at that time, if that is acceptable to you and the commission.
Yes, I think that's a good way to proceed. And folks, without the benefit of being able to be face-to-face and see one another, we are asking folks to keep their comments to 3 minutes, because there could in fact be that we have additional people who want to speak. At 3 minutes, I will just say 3 minutes. And so please, at that time, conclude your thought. And we really do appreciate the time that everybody takes out of their day to come with us and share your thoughts with us. It's really a very important part of our meeting to all of us. So with that, first speaker, please introduce yourself for the record and go ahead.
Thank you, Chair George. This is Stephanie Caldera. The first speaker I have today is Mark Riskadal, who should now have the ability to speak. If you would go ahead, please.
Great. Are you able to hear me okay?
We hear you great, thanks.
Super. Thank you, Stephanie and commissioners. For the record, my name is Mark Riskadal. I'm the executive director of NEDC, the Northwest Environmental Defense Center at Lewis and Clark Law School in Portland. Though I've spoken to the commission most recently about the urgent need for diesel particulate reduction, especially in Oregon's largest urban areas, and I remain disappointed by the commission's unwillingness to promulgate regulations or even a non-binding resolution responsive to that problem. I'm weighing in today on the commission's refusal to move forward with the modest, long overdue, and gradually phased in air contaminant discharge permit fee increases proposed by the department today for your consideration. When the commission defers to the time-worn jobs versus the environment talking points of the wealthiest industrial polluters in the state, it does a disservice to all Oregonians. Modest fee increases in support of a license to pollute a public resource ensure adequate regulatory oversight of that pollution by state agency employees and private sector environmental compliance personnel. In other words, people performing jobs that protect public health and the environment. The interests of regulatory certainty, fostering progress and innovation, reducing pollution, creating and sustaining environmental compliance jobs, and protecting public health and the environment are all served by an adequately funded system of environmental regulatory oversight. Oregon deserves as much. Finally, thanks to Courtney Brown and Karen O'Donnell and the rest of the DEQ team for their efforts dealing with Northwest Metals. The owner of that business is quite honestly the most unscrupulous, dishonest person I've ever dealt with in 20 years of dealing with unlawful actions harming the environment and public health. NEDC spent hundreds of hours prosecuting a federal Clean Water Act lawsuit against him related to illegal discharge of the most heavily contaminated stormwater pollution I've ever seen at his former location. We prevailed on all counts. He was judged in contempt of the court's order, and he tried everything he could possibly think of in an attempt to escape liability. So thank you to the commission for supporting the penalties and the full scope and scale of the enforcement actions taken by the agency and the decision by the ALJ in that matter. Thanks for your time.
Thank you, Mr. Riskadal.
Thank you. So the next person who has indicated an interest is someone who is shown on my screen as Dancing Roots. And so at this time, I will unmute your line and you should be able to present comment. Thank you.
Welcome. Please introduce yourself for the record. We
Can
can hear you.
Great, thank you. I'm sorry, my computer says Dancing Roots. That's the name of my farm. Chair George and members of the Environmental Quality Commission, thank you for letting me speak. My name is Sherry Serkan, and I'm the Executive Director of Friends of Family Farmers. That's what my screen name should say. We're a nonprofit that supports and advocates for ecologically responsible farmers and ranchers in Oregon. Today I'm speaking as a member of Stand Up to Factory Farms, a broad coalition of family farming, environmental, food safety, and animal welfare organizations that represent thousands of members across the state. We recently submitted a letter to DEQ urging them to include regulation of mega dairy emissions in their greenhouse gas reduction rulemaking plans. And we were deeply disappointed to hear that our recommendation was ignored. Emissions from mega dairies include toxic and volatile greenhouse gases such as methane, carbon dioxide, and nitrous oxide, all contributors to climate change. The large quantities of manure mega dairies produce are also a significant source of air pollution that contributes to regional haze in the Columbia River Gorge. Despite several attempts to codify and enforce the recommendations of the 2008 Dairy Air Quality Task Force, Oregon is still without controls for this significant source of greenhouse gases. As we saw with the approval of the disastrous Lost Valley mega dairy and its recent purchase and new CAFO permit application by Washington-based Easterday Farms, Oregon is an attractive state for new mega dairies to set up shop. If Oregon is serious about reducing greenhouse gas emissions, it's essential that mega dairies be held clearly accountable for their contributions. The Stand Up to Factory Farms Coalition urges this commission to reconsider and include the regulation of mega dairy emissions in your plan to reduce Oregon's greenhouse gas emissions. Thank you.
Thank you.
Thank you. This is Stephanie Caldera. The next person I have indicating an interest in speaking is a phone number that starts with a 971 and ends with 4180. At this time, I'm going to unmute your line. If you would please state your name for the record.
Good afternoon. My name is Catherine Chuddy. I live in Vancouver, Washington. I testified before you in November of 2019, reminding you that our children have been in court in states across this country, including in Oregon and Washington, for more than a decade to make their case that states have the obligation under the public trust doctrine to protect vital resources from the impacts of catastrophic climate change. Our children point out that states are currently failing to preserve and protect those resources for their future. States argue against our children, pointing to legislative and executive branches rather than the court as the protectors charged with fulfilling that obligation. Our children have turned to the courts because they see our state agencies and representatives repeatedly acting against their best interests, putting their present and future welfare at risk. Oregon DEQ's proposed draft air permit that would allow global partners to ship 2 loaded oil trains a day through our communities, passing through Vancouver, Portland, and Columbia County towns to the facility near Clatskanie, Oregon, is a serious threat to the safety, health, and well-being of all of us who live in our region. This is yet again a glaring example of what drives our young people to despair in the face of decision-making that fails to protect their interest. Last November, I asked that your commission recognize the connection between permitting new or expanded fossil fuel infrastructure and the relentlessly worsening climate crisis affecting us all. The truth is, we all will suffer unless we keep fossil fuels in the ground. Now we are in the grip of a global pandemic, and the regulator who should be protecting us is nevertheless moving forward to issue an air permit renewal for a crude oil terminal that will bring worsening pollution as well as significant public safety risks on both sides of our river. This betrayal of trust, if you allow it, will saddle our children with decades more of fossil fuel use. This is unacceptable. As I said in November, and I'll say it again, what we need is an immediate transition to a just and clean energy economy that leaves fossil fuels in the ground. This starts with your agency saying no to permitting fossil fuel exploitation at the expense of our children who inherit the earth and deserve so much more. Thank you for your time and this opportunity to testify.
Thank you for joining us today.
Chair George, the next person who has indicated an interest in speaking is Dan Saris, who I will unmute now and should be able to provide comment.
Welcome.
Thank you. Chair George, members of the Commission, thank you for the opportunity to address you today. My name is Dan Sears. I'm the Conservation Director for Columbia Riverkeeper. We, along with our 13,000 members and supporters, are members of the Stand Up to Oil Coalition. We remain deeply concerned about DEQ's approach to permitting oil by rail facilities. In past meetings, we've addressed the Commission about the ease with which oil companies have converted mothballed ethanol and asphalt facilities into oil by rail terminals. These conversions put communities at risk by increasing reckless oil by rail traffic. Currently, Oregon DEQ has proposed a draft air permit renewal that will allow global partners to ship 2 loaded oil trains each day through our communities to global partners, Columbia Pacific Biorefinery near Clatskanie, Oregon. Owners of the facility tout their plans to ship ethanol and renewable diesel. However, DEQ's proposed permit will allow the owner, global partners, to ship crude oil as well. We are disappointed that despite receiving the application for Global's permit renewal in May of 2019, DEQ has chosen to conduct its public process during a global pandemic this month without the benefit of an in-person hearing. Instead, DEQ granted a 2-week extension to a written public comment period. This is a highly controversial permit, and the lack of an in-person hearing significantly limits the public's ability to air its concerns. DEQ shouldn't rush to issue a permit that could lead to a significant increase in oil trains through the Columbia River Gorge and the Portland metro area. The stakes are tremendously high for this decision. There is a strong regional consensus that oil trains are unsafe. The city of Spokane stated, quote, "A small explosion in the Spokane downtown would cause a significant, if not catastrophic impact," end quote. The city of Astoria resolved that oil trains pose, quote, "unacceptable risk levels for spills of crude oil entering the Columbia River, causing significant impacts to its ecosystem," end quote. The city of Vancouver stated, quote, "Derailments, spills, explosions, and fallout pose a serious threat to this community," end quote. And there are many other similar resolution statements from communities like Stevenson, Mosier, and Washougal. The company says that it plans to ship ethanol and renewable diesel, but wants to retain the flexibility to ship crude by rail again in the future. Unfortunately, there's nothing in the permit that would prevent the company from shipping exclusively crude oil, putting communities and our environment at risk. When the next oil train derails, spills, and burns, we don't want it to be because Oregon DEQ has rushed to approve a permit renewal for crude oil trains to a company that could just as easily have shipped ethanol and renewable diesel. We urge EQC and DEQ to take a much harder look at how this process is unfolding and to rethink whether this is really the right time to give a permit renewal for increasing bomb train traffic through Oregon and Washington communities. Thank you.
Thank you.
Chair George, the next person I have in my list to comment has a display name Damon Mott's Story, whose line I will now unmute, and you should be available to present comment.
Good afternoon, Chair George and Commissioners. Thank you so much for the opportunity to testify today. My name is Damon Mott Story. I am the Healthy Climate Program Director with Oregon Physicians for Social Responsibility, which represents approximately 2,000 health professionals and public health advocates from across the state. And we are really guided by the values and principles of medicine and public health towards addressing environmental pollution and climate change as the public health crises that they are. I'm here today to comment on a couple of different things. I wanted to add my support to Mark Riskadal's statements about the indirect source rule petition and express my dismay that that was denied, and express my fervent hope that the Commission will take action on reducing pollution from diesel in indirect sources as soon as possible. Second, I wish to speak to the Global Partners facility, Columbia Pacific Biorefinery near Clatskanie, Oregon, and the proposed air permit renewal. As several other people have said, this is a terrible time to be permitting a facility of this nature, and the permit would allow the company to ship oil trains through Portland, Vancouver, and Columbia County towns. If the company says it plans to ship ethanol and renewable diesel, then that is the only thing it should be allowed to transport. The permit should not allow for crude oil transloading and transportation. This has very real impacts on the communities along rail lines that feed into this facility. And this is no time to be conducting a robust and thorough public engagement opportunity. So I strongly urge the Commission to reconsider moving forward with this process and to consider a number of different important issues related to this permit in the interest of protecting public health and reducing our impacts to climate change. The Governor's executive order directs all state agencies to be doing everything it can be doing to reduce our climate emissions along the new benchmarks that were set in the executive order. And by permitting and allowing for crude oil to go through the Global Partners facility, we are in fact directly allowing increased oil train traffic through communities in Columbia County, Multnomah County, on both sides of the river, and all through the Columbia River Gorge. This is a direct impact on health and safety for the communities that live along these bomb train routes. And it also moves us further and further away from the direction we need to be going in order to reduce Oregon's greenhouse gas emissions along the targets that the state has set. I want to also mention that Washington State has adopted a 9 PSI pressure limit for vapor pressure. And so DEQ's vapor pressure limit of 12 PSI in the Columbia Pacific Biorefinery permit is too high. And there are a number of toxic pollutants that need to be considered, such as hydrogen sulfide. Thank you for the opportunity to testify today.
Thank you for joining us today.
Thank you, Chair George. The next person I have indicating to speak has a display name of Christina Martin. Your line is now.
Yes, hello, commissioners. I wanted to thank you for hearing me out on the issue of the smoke management rules. We have seen firsthand the serious effects on health here in Southern Oregon, with piles burned with huge sheets of polyethylene plastic on them, often on days of inadequate ventilation. We are now especially concerned as these burns are scheduled to go on full speed ahead, with 7,000 to 10,000 just behind our back fence. This coincided with COVID-19 this fall, which of course attacks the lungs and is a serious respiratory illness. The current smoke management rules allow the Oregon Department of Forestry to give exemptions from clean air standards outlined in the Clean Air Act, allowing agencies to burn on days of inadequate ventilation, and instead calling for communities to lift the ceiling on their safe limits to facilitate larger scale burning. Two statutes in particular represent a great danger to Oregonians, and we have experienced this in the Applegate Valley when we recently documented in photography and video heavy smoke that blanketed the community of Williams for 3 full days, December 16th through the 18th of 2019. Clearance was given by ODF to the BLM, whose contractors were directed to burn on days of inadequate ventilation, and agencies like the Forest Service, BLM, and the BLM pay the ODF for permission to burn by the ton on slash. They pay by the ton to burn that slash on such days for these permits. There were additional numerous days where smoke was thick and visible in Applegate Valley and Grants Pass from Forest Service and BLM burns. We and many others believe the following rules need to be changed if we are to move forward with fuel reduction, which we truly believe in, while protecting human health. Additional statutes related to forecasting and inventories may also need to be addressed, but I've outlined 629-048-0210. Large-scale burning of polyethylene plastic does not take into account the double VOC emissions data for plastic-covered piles over dry piles. This data was left out of the 2016 EPA ODF study conclusion, and that conclusion was the basis for the approval of these current smoke management rules. Plastic debris and melted plastic remain on the forest floor after these burns. I've sent you a video and photographs of that, and use of we're encouraging use of craft paper or plastic removal prior to burning as the previous best practice. Also, Rule 629-048-0180, the rule encouraging communities to exempt themselves from clean air standards set by the Clean Air Oregon, not only violates those acts, but it is in violation of smoke management rule that calls for maintaining air quality while maximizing the burning. So we feel that complicating the burning is the emissions will exceed healthful standards. And in conclusion, we wanted to say that community response plans also.
3 minutes.
Oh, yes. I just wanted to encourage you to read the supplement I gave you because it's very thorough on the test. Thank you.
Thank you very much. Our next speaker.
Yes, thank you, Chair George. The next person I have in the speaker's queue is Jonah Sanford, and I will unmute your line now if you would please proceed.
Great, thank you, Stephanie. This is Jonah Sanford. I'm the staff attorney for the Northwest Environmental Defense Center. Thank you for the opportunity to participate today. I'm also commenting today on DEQ's plans to move forward with the permitting process for global partners, which would allow this facility to ship crude oil through its facility in Clatskanie. This crude oil, of course, would be delivered to the facility via oil trains that would travel through Portland, Vancouver, and several Columbia County communities. This facility and this specific permit have rightfully been the focus of a great deal of public attention and controversy this year. There's an enormous amount of public concern about global partners' intentions for this facility and confusion about what type of oil the company actually plans to ship in the coming years. So with all this in mind, I believe DEQ's plans for moving forward with this permitting process right now are extremely problematic. The current plan is to hold a single online public hearing for this permit which would authorize activities that could ultimately have dramatic impacts on local air quality, significant climate impacts, and for waters along these trains routes. So I'm taking this opportunity to urge the agency to take a step back and slow down this permitting process. It's essential that the public receive a complete picture of the risks associated with this facility and to give the public an adequate opportunity to have its voice heard. The current plan to move this permit through in the middle of this public health crisis simply does not do that. Thank you.
Thank you.
Chair George, the next name that I have on my list is Ryan Rittenhouse, whose line is unmuted and should be able to present comment.
Yes, hello. Thank you very much for accepting public comment today. My name is Ryan Rittenhouse. I'm the conservation organizer with Friends of the Columbia Gorge. We are also a member of the Stand Up to Oil Coalition, and we are the only nonprofit that specifically and exclusively focuses on preserving and protecting the Columbia River Gorge National Scenic Area. I'm talking to you today, as you probably would guess, about the Global Partners facility, mostly because every train that would bring crude oil shipments to that facility would come through the Columbia River Gorge National Scenic Area. And that's extremely unacceptable. Hopefully everybody remembers the disaster that happened in Mosier a number of years ago. And that, as bad as it was, that disaster could have been far, far worse. We got lucky on a number of counts, and we can't really depend on that happening again. And it doesn't matter what kind of oil gets shipped through the gorge either. They all have their own unique problems that are not adequately addressed by current regulations, safety measures, or technology. The only way to ensure the safety of the National Scenic Area and the communities along the rail route is to not ship crude oil in trains. And a facility like Global Partners is a very clearly transparent effort by the oil industry to circumvent normal public regulations, as you would with a new oil terminal. There were 12 fossil fuel terminals, 6 oil terminals proposed in the last few years, new terminals throughout the Pacific Northwest, all of which received massive public opposition and all of which got defeated because they had to go through a full-fledged regulatory process with full public comment from the public and everything that goes with that. With a facility like Global Partners, where they are able to finagle the permitting process for existing permits and able to switch back and forth between operations for ethanol and then switch as they desire back and forth to crude oil, is a gigantic loophole in our regulatory process. And the EQC and DEQ needs to close those loopholes and prevent any company like Global from switching back and forth between ethanol, which is what they were originally permitted for, and a product like crude oil. The dangers are just far too severe, not only for our communities, not only for the National Scenic Area, but for the world in general, because that product, of course, is a massive driver of climate change, whereas ethanol is a far less severe impact. So, in conclusion, please bear in mind the cumulative effects of all this, all the rail line impacts, because this just doesn't affect the community where this facility is located. It affects the entire rail line communities up and down, not only in Oregon, but it also in Washington State, Idaho, Montana, and even North Dakota. Thank you very much.
Thank you.
Chair George, the next name on my list is Samuel Diaz, whose line I am unmuting at this time and should be able to present comment.
Great. Good afternoon, Chair George and Commissioners. My name is Sam Diaz. Today, I am representing Portland Mayor Ted Wheeler's office to reaffirm the city's priority in guiding a just transition to a clean energy future. First, we would like to thank you for your work to create healthy communities throughout Oregon. The public health crisis underscores the connections between public health, our environmental quality, and the risks to our most vulnerable communities. The Portland Mayor's Office is here today in support of our public health experts, our first responders, and those who have been affected by the COVID-19 crisis. While our environmental policies are upstream responses compared to the direct emergency response like those we see in our hospitals or in our shelters, there is mounting evidence linking COVID-19's mortality rate amongst community members who have suffered long-term exposure to air pollution. When we examine this data in Portland, we are seeing that nearly 40% of people of color in Portland live within 1.25 miles of the city's largest sources of air pollution, making them susceptible to chronic conditions that mean the difference between life and death if they contract COVID-19. This evidence underscores the urgency and importance of making sound decisions when it comes to environmental policy and applying a racial equity lens to decision-making. We urge the Environmental Quality Commission to adopt and enforce precautionary measures when state agencies, DEQ included, are reviewing permit applications that, if approved, will increase the risks and exposure to harmful pollution for communities. We urge you to require robust analyses of the current and anticipated impacts from applicants. We urge you to engage those most impacted, including local jurisdictions, in these decisions. I want to be clear, as a staff member of an elected official, we are not asking for engagement with local jurisdictions because we believe an elected official should decide upon a healthy environment. Rather, we support agency engagement with those in the affected community because residents and their government agencies can help share information about localized impacts, reports, protections needed, and strategies to help your decision with the best available data. We know the City of Portland cannot achieve the necessary outcomes to safeguard Portland residents and our environment without you, without your collaboration, without your adherence to and respect for the best available science, and without your concern and centering protections for the health of our communities, especially our most vulnerable. We urge the EQC to join us in making choices like opposing all project proposals that increase the amount of crude oil being transported by rail to help us weather the current pandemic while setting a better course for the future of our communities. Thank you for your consideration.
Thank you.
Chair George, I have 3 people remaining on my speakers list, just to indicate that to you and to the people connected on our system today. The next person is Dale Feek, whose line is now unmuted.
I'm Dale Feek, Chair of Washington County Citizen Action Network and also Project Director of Hillsborough Air and Water. Chair Kathleen George, Vice Chair Barrasso, and Commissioners Kyle, Mosby, and Addington. At the Environmental Equality Commission meeting March 18th via telecommunication, you denied the indirect source petition. After you voted unanimously denied the petition, which severely disappointed the petitioners, you, Chair George, read a prepared draft resolution that supported the indirect source petition conceptually and also specified specific actions with a timeline that you recommended that the DEQ and the Environmental Equality Commission do to accomplish many of the petitioners at once. The EQC tabled voting on the resolution, decided to act on it within a month. My question is, when are you going to discuss and vote on your draft resolution? Washington County Citizen Action Network, Hillsborough and Water, want you to pass that resolution and take actions on it as stated in it. Today, Director Whitman, in one of his slides, showed the same slide in the various sectors that indicated that no way is Oregon going to meet those goals without drastic Environmental Quality Commission decisions to reduce greenhouse gas emissions. Previously, one of my previous public comments before you, I exclaimed, "Oh crap, we're screwed." Well, I think maybe we still are, but with the leadership of you and the director and the staff, maybe with that very informative and hard facts, you will make decisions and support Governor Brown's plan to have a chance for all to meet the goals. Hillsborough Air and Water, I want to emphasize water, okay? And since I've been involved in the commission since 2013, I've transparency of trying to get a good data system where you can get permits from water and air and combine them. Important because you need to take a look at in the water and in the air and put together in permits. That happens once you get it optimized. in an instance. The DEQ finally, because us activists made public comment, finally got DEQ to recommend a fine to Intel because Intel in Washington County violated 3 major Permit Clean Air Act rules having to do with fluorides, 2 of them, and 1 of them having to do with construction of their sites without a valid construction permit. So it's very important that you as commissioners take action when it's recommended and do extensive study on what needs to happen. So I was disappointed that there was not a second on your motion, Commissioner Barrasso, and that money wasn't allotted for more money for permitting action. It needs to please reconsider in July. Thank you.
Thank you.
Thank you, Chair George. And I believe I do have one more person in the queue, Theodore Songus, whose line I will unmute now and should be able to present comment.
Thank you. Good afternoon, Commissioners. I'm Dr. Theodora Songus. I'm an environmental health scientist and epidemiologist, and I have great respect for the difficult work that you do and for your resilience in working under current conditions. However, I feel it's my duty to comment on the actions of DEQ on its draft air quality permit for the Columbia Pacific Biorefinery. We are faced with a double-barreled global emergency, catastrophic climate disruption, and the COVID-19 pandemic. People worldwide are fighting for their lives. It is unconscionable and cruel that the Oregon Department of Environmental Quality has proposed an air quality permit with long-term public health and environmental impacts with little attention to public input and any concern for transparency and the changed exigencies for the public during an epidemic. This is not business as usual, and it may never be that again. DEQ needs to remember that its job is to protect the public health and the environment on which we depend for life, and stop bowing to the corporate interests, hurrying to make a profit at any cost while we are distracted. Furthermore, on July 24th last year, I testified on behalf of Oregon Physicians for Social Responsibility at a DEQ hearing on this very topic. We pointed out the poor record and lack of transparency of the companies applying for this permit. We pointed out that the proposed permit did not clearly separate equipment used for ethanol from equipment used for oil, and that multiple tanks were proposed for use for oil as well as ethanol. Apparently, DEQ was not listening. The current draft permit does not distinguish between tanks used for ethanol production and oil transloading at the Columbia Pacific Biorefinery. We also pointed out that using tanks interchangeably for crude oil and ethanol imposes serious risks of exposure to toxic air pollutants and explosions. In order for DEQ to minimize these and other risks to the public, DEQ must prevent global partners from building, refurbishing, or buying tanks to make ethanol and then converting these tanks for use for shipping crude oil. By its actions on this permit, DEQ has violated the public trust. Again, it needs to withdraw this draft permit and develop a process that encourages and values full and informed public participation. Thank you very much for your attention and for your work.
Thank you.
Chair George, I have one additional raised hand in the comment space, but after the next line, Elijah Saitas, would be the end of the speaker's queue that I have.
Okay, great. Let's hear from this caller.
Hey everyone, greetings commissioners. Thanks for allowing me to testify here at the end. Couldn't figure out how to raise my hand. So my name is Elijah Saitas. I'm a community organizer with Center for Sustainable Economy. We're an Oregon-based environmental economics think tank and advocacy group. With our coalition partners, we work to advance new policies for a more just economy in our region. In the face of the twin crises of COVID-19 pandemic and global warming, this commission has a unique responsibility to uphold the public trust of all Oregonians. And it needs to ensure that DEQ takes seriously the clear relationship between increased particulate emissions and mortality rates from COVID-19 as well as following the governor's executive order with its clear mandate that DEQ address the urgency of reducing greenhouse gas emissions in all of their decisions. I want to talk about Global Partners' proposed crude oil transloading permit as well. It is disheartening that DEQ is moving forward with hearing Global Partners' permit this month in the midst of a global pandemic and through a single online public forum. Global Partners' permit proposes to allow transloading ethanol, renewable diesel, and crude oil. And as my colleagues have stated in public statements and on their public website, Global Partners claims to have switched its equipment to handle crude to now process ethanol and renewable diesel. And that's also intending to produce ethanol at the site. But DEQ needs to be very, very careful what it allows in this permit. And specifically, it should not allow this permit to move forward if it grants the ability for Global Partners to move crude. Global Partners has a long history of violating permits at its terminals in the Northeast by increasing the amount of chemicals and fossil fuels that it handles and without giving notice to regulators. I'm going to list some of these. On January 21st, 2005, Global Partners and the EPA entered into a consent decree and which Global Partners agreed to pay $500,000 because, quote, it failed to comply with annual average standards for olefins and exhaust benzene, NOx, and toxins, and the respondents' noncompliance resulted in emissions 78 tons in excess. And then as well, Global Partners recently in 2014 spilled 100 gallons of crude oil in Albany, New York. And at the time, they did not reach out to the Albany Fire Department. A county executive was quoted saying, "Something went wrong. To me, it's another cover-up at Global Partners. They're not trying to be a good partner." Again, on August 2nd, 2016, EPA issued a violation of Clean Air Act for Global Partners for violating federal air pollution standards and underreporting the amount of ozone-producing compounds being emitted when it sought permission to handle more crude oil trains. The terminal that connects to Global Partners' Columbia Pacific Biorefinery has also received at least 5 railroad safety violations. And those terminals are built to handle crude oil. And they were specifically purchased in 2013 at the same time that Global Partners purchased the Columbia Pacific Biorefinery. And at the time in their investor statements, they said they were building a virtual pipeline by rail. We have all indications here that Global Partners is planning to potentially flip its terminal to move crude oil. And this is an unacceptable violation of the community's trust and the health and well-being of Oregonians. I just urge DEQ to take initiative and not grant this permit unless the crude oil is removed from it. So thank you so much.
Thank you.
Thank you, Chair George. This is Stephanie Caldera, your EQC assistant. At this time, I do not have anyone else indicating in my speakers list to present comment and noting time. I'm just checking in with you, Chair George, about how you would like to proceed.
Thank you very much, Stephanie. Yes, I'm very glad that we got to hear from all the speakers who had requested to speak, but considering the time, we do need to move on to the director's report. As we always do, I want to thank everybody who checked in today to share their thoughts with us. It's a very important part of our process, and I thank each of you for sharing your thoughts with us today. Director Whitman.
All right, thank you, Chair George. Commissioners, for the record, this is Richard Whitman, DEQ Director. And I am going to present the Director's report, agenda item H. And I'm going to try to, we're almost back on track time-wise. We're still a bit behind, so I'm going to try to catch up a little bit more here. I want to start, there are only a couple of items in the written director's report that I'm going to touch on because I think they were probably of particular interest to commissioners. But if there are questions about other aspects of the director's report, please, commissioners, feel free to ask me about them. But I'm going to touch on 2 items that appear toward the end of the report. One relates to things going on in the Northwest region, DEQ's Northwest region, and then also in DEQ's Western region. In the Northwest region, there's a very short written report on Portland Harbor, the Portland Harbor Superfund cleanup. I want to provide just a little bit more verbal information on current status with the Superfund effort. As you know, it's now been underway for more than 20 years. We are moving well into the phase now of actual final design of the cleanup in the harbor. As noted in the director's written report, we've got a combination of agreements between EPA and responsible parties for the final design work, and then in a couple of instances where parties were not willing to enter into agreements, EPA has issued unilateral orders directing those companies to proceed with the design work. There were 4 companies that also petitioned EPA for a change to the record of decision for the cleanup, and the main verbal update here is that EPA just denied that request. And so, again, EPA is moving forward with this phase of the in-water portion of the cleanup for Portland Harbor. Speaking for DEQ, we're very pleased to see that progress and continue to work closely with EPA and responsible parties, both on the in-water piece and also in upland work to assure that recontamination does not occur. The other report that I want to touch on is with regard to Pembina Jordan, the Pembina Jordan Cove liquefied natural gas terminal and associated pipeline that is proposed for Coos Bay, and then the pipeline connecting that terminal with a compressor station in Malin, Oregon. There have been some significant developments in the Jordan Cove permitting, and most notably, the Federal Energy Regulatory Commission has issued licenses for both the LNG terminal and for the natural gas pipeline. There have been a number of petitions filed for reconsideration of FERC's decision, including from the company itself, as well as from the state of Oregon on behalf of a number of state agencies, including DEQ, but also including other agencies. And those are pending before FERC now. In addition, the company, Pembina Jordan Cove, has filed a petition for an order from FERC finding that DEQ waived its authority under Section 401 of the Federal Clean Water Act to certify whether or not the proposed activities are in compliance with Oregon water quality standards and the programs implementing those standards. Our response to that petition is due in early June. We're working on it now. As I think the Commission knows, this was disappointing to us because the company had indicated that it was going to reapply following DEQ's denial of a water quality certificate for the project last spring. And we've been working with the company to be clear about what information is needed since that time. So this is a bit of change of direction from the company. That said, it's not entirely a surprise either that the company filed this petition. It's disappointing, but not a surprise. Somewhat relatedly, EPA has been working on issuing a rule interpreting Section 401 of the Clean Water Act to, and this is my opinion, significantly limit state's authority and voice in reviewing federal permits and licenses for their impacts on water quality and whether or not they meet federally approved water quality standards in the states. EPA has not yet issued that rule, but may be issuing it in the very near future here. It's unclear at this point how that may affect these proceedings, but it is something that we are watching very closely. So I think I would sum all this up by saying that DEQ continues to have significant concerns about water quality impacts of the proposed facility. We would hope that the company would follow the law and reapply for certification with Oregon DEQ, but we'll see what happens. The last thing I'll say about Jordan Cove is to note that although FERC has issued its licenses for the project, there's another significant federal permitting action that has not occurred yet, which is the U.S. Army Corps of Engineers issuance of 404 dredge and fill permits for this project as well. The Corps was supposed to have issued decisions at the same time as FERC under the Federal FAST Act, but has not done so and continues to review the project. So there are a lot of moving parts with regard to Jordan Cove, and as you all know, this project's been pending for a long period of time. We continue to want to make sure that we represent Oregon's interests well in reviewing this project and follow the law, and that's what we're doing. So I'd be happy to take any questions on either of those things, Chair George, and if there are not, I have a couple of other things that I want to mention as part of the director's report. But let me pause there.
All right, do folks have questions on that portion of the report?
Okay, thank you. The next thing I want to touch on is some positive news. And every year, governments really across the country celebrate Public Service Recognition Day, and that day was this past Wednesday. Let's see, today's Thursday, so I guess it was the 6th. And we had a number of nominations from managers in DEQ for their staff who have really done exemplary service over the course of the past year. So I very briefly want to touch on those nominations here. And there are two types of nominations. One is for commitment to state service. These are individuals who have served the agency either for a very long period of time and showed great dedication to the state and to DEQ, and one individual who is very new to the agency, but just in a very short time has shown great initiative. And so let me speak to those 5 individuals very briefly. And the first individual is Edith Morin, and she is with our air quality program and an administrative specialist. And she actually began as a vehicle inspector in our in one of our clean air stations. She's now been with the agency over 30 years working. So a shout out to Edith for her long years of service. The second person is somebody you heard from earlier today, who also has been with us for over 25 years, and that's Karen Williams. She did a great job in her presentation earlier today. She's done a number of presentations to the commission recently. She actually has moved around between the air program, water program, and land program, and it's just really does an all-around outstanding job very clear in her public presentations. I've seen a number of times, just really exemplary work. The third person is Jessica Cohen, who is new to the agency. She started just 11 months ago. She's working in the environmental cleanup program and helping us with modernizing some of our technology in that program. It's just been very inspiring in a short period of time. And then the last two are individuals, both of whom have worked in DEQ for over 30 years. One is Stephanie Holmes, who spent most of her time with our underground storage tanks program. Stephanie actually just retired, but she worked for DEQ for almost 30 years. And then finally, the last person is a name you have heard before, and that's Peter Spendelow, who is one of the founders, if you will, one of the founding fathers of Oregon's Volatile program, and continues to work with us on modernizing Oregon's recycling system. And is really an inspiration to people working in that field in Oregon. And Oregon is really, again, a national leader in that field. So a shout out to those five. We will be giving certificates, recognizing the service of those individuals. And Chair George, I'm going to ask you to sign those along with me, and we'll get them out here in the near future. And then finally, I do want to touch the other type of award is for change champions, folks who have really been instrumental in the agency in the last year in driving positive change in the agency. And so just a quick mention of those individuals: Lauren Wertis, who's with our communications program. She works for Harry Estev. Lauren recently did a stint in our Emergency Command Center Joint Information Center on the COVID response for the state. So we lent her to the ECC as a communications specialist for that effort. And she did just a wonderful job. I heard feedback from a number of folks about how lucky we are to have Lauren working for us. Fortunately, she did make it back to us and is back on the team working for us again. The second person is Zach Coach, who works at the lab as an air quality monitoring specialist. We've had a lot of innovation in that program with some low-cost ways of expanding the air quality monitoring we do, and Zach has been a leader in that area. Third person is Becky Anthony. You heard about our integrated report on water quality and the report to EPA and the public about how we're doing in terms of making progress and improving water quality. Becky led that team. We got the integrated report into EPA at the beginning of April. And again, that's major modernization in that program and upgrade of our system and setup for reporting on trends in how we're doing in water quality. And then a couple more people, Patty Hahn and Oren Schmidt are trainers in our Central Services Division. And those two have really spearheaded our new onboarding program for new DEQ employees. We frankly did not have an onboarding program to speak of before those two really put together a very thoughtful, very thorough onboarding program, which we're now using, and I've heard a lot of good feedback from new employees in the agency over the last couple of months. And then last two, Jonathan Giska, who's in our Cleaner Air Oregon program. He is an engineer. He's really been kind of a point person for Cleaner Air Oregon, working with facilities who are entering into that program and going through an analysis of their emissions. And so really just a key person in getting Cleaner Air Oregon off the ground successfully. And then finally, Gary Byer, who works in our vehicle inspection program. You heard earlier today about some of the things we're doing in that program to make it possible for people to get certificates now and get their cars registration updated, and then come in at a later date for testing. Gary was really instrumental in putting that program in place, which we believe is going to shorten waiting times for the public when we do reopen the VIP testing stations. That'll give people more time to come back in and actually get their vehicles inspected. So collectively, a great shout out to some great DEQ staff folks that I just wanted to recognize. There's just a ton of work, good work going on every day here at DEQ, and we don't often get the opportunity to recognize that. And in the midst of a meeting that is focused on enforcement and fee increases and the effects of climate change, it's just nice to be able to talk about the great positive contributions that staff are making. So I'll stop there on that item. The last thing I want to talk about was referred to in the public comment period, and it is the indirect source petition and the discussion in the commission about a resolution. We have not forgotten about the indirect source petition and the resolution, and I want to just briefly tell the commission where the department is on that work. As you know, we have a major study and analysis of off-road diesel emissions that is just being completed, and that we want to analyze carefully and come back to you with very informed recommendations that are really informed by the data from that very detailed survey. So that effort will occur over the next 2 to 3 months before we're really in a position to come back with those more finely tailored recommendations for the commission. The second piece of this is with regard to on-road diesel emissions. You heard at a very high level earlier today about work that's going on the statewide transportation strategy. And the work plan for that is going to be released toward the end of June. I'm going to give you a little early preview of the work plan. And one thing that we expect is going to be in there for consideration by you is a portion of that implementation work. And that is that the Environmental Quality Commission consider as part of that effort adoption of California's standards for low NOx, low PM, and greenhouse gas emissions from medium and heavy duty vehicles. California is in the middle of a rulemaking. The California Air Resources Board is in the middle of a policy-making process right now, but just like with light-duty vehicles, passenger vehicles, there is authority under the Clean Air Act for other states to follow California vehicle standards. And in part because of federal action to roll back vehicle standards at the federal level, and this is my personal opinion, I believe that one of the things that Oregon can do to offset some of the negative effects of that, both in terms of greenhouse gas emissions, but also in terms of regular pollutants like particulate from diesel and nitrous oxides, which are a precursor for ozone, which we have a problem with in Oregon, is to look at medium and heavy duty vehicle standards. Somewhat buried in the GHG presentation was also a chart, which you can go back and look at your leisure now, which showed trends in different sectors of emissions over time, particularly in the transportation sector. The one area where we see a very significant challenge in terms of increasing emissions, this is on the greenhouse gas piece, is on medium and heavy duty vehicles. So there is a real need to look at that piece if we are serious both about greenhouse gas emissions and about some of the immediate public health challenges that led to the indirect source petition being filed in the first place. So more to come on this, but we are not by any means done with work around diesel emissions. It is being looked at very actively by staff, and you are going to have some specific opportunities later this year, both with regard to the off-road diesel study and follow-up to that study, and then with regard to vehicle standards to engage in this in more detail. There are other pieces also. I'm just kind of scratching the surface here, but those are two of the more significant pieces.
Well, and while we're on that topic, I wanted to just take an opportunity to at least to some small degree address the issue that Dale raised about the proposed draft resolution. And I think that was an intention on my part, anticipating that there was at least the possibility that the proposed rules or the proposal on the table would not pass, to articulate and take some sort of affirmative action, expressing our commitment to the goals, many of the goals that lie within that program, and in many ways, Richard, to kind of speak to some of the programmatic components that are nestled within other parts of the work that DEQ is already doing, or that they have work plans to do at this time. So that was kind of the beginning of the idea of a draft resolution to express some affirmative commitment to that. And one of the challenges we have as EQC commissioners is because of our dedication to public process and of our Oregon rules that require that, we're not allowed to talk about, I can't just call up Molly or call up Wade and talk to them about an idea I have for an upcoming meeting. And so there's really no way to have that kind of conversation in advance, because that would be seen as kind of planning outside the public eye. It could be seen as a sequential meeting, essentially. There's just a lot of restrictions on these things. So I think it was very disconcerting to several of the commissioners to kind of have this draft resolution kind of sprung on them in the previous meeting. And I don't think that's necessarily anything to do with any lack of support for looking into these matters and pursuing them the way the work plans have been laid out. But also just to share that, the feedback we got from those folks who happen to be, disappointed with the proposal not passing, the resolution didn't seem to hold any value to most of them anyway. So we just decided, I think, to let it go and to continue with the work plans already in place, and to bring that work back to the table as part of existing DEQ work plans. So I just wanted to go ahead and comment on that, because I think it was a good intention that just kind of didn't work out and didn't accomplish what its intention was. I had one other question, Director, and I wonder if you can just speak to many of our folks who called in for public comment today were addressing the Global Partners permit proposal. And can you speak to us about the time frame for that and kind of where we are at, where DEQ is in the process on that permit?
I will do my best, Chair George. I believe we've got Deputy Director Leah Feldin, and we may have Ali Mirzakhalili on the phone also, who can provide a little bit more detail. But I know we had a number of requests for additional time for people to submit comments on the draft permit, and I know we did not extend the comment period to the extent that everybody wanted. We kind of split the baby extended it some, but not as much as I think some folks wanted. I hear the issue about processing of ethanol versus processing of crude oil. It's not a new issue for this facility. It's been an issue with this facility before. It's something that I will ask some questions of staff on as we work on this permit. There are limits on what we can and can't require under the law. It is a standards-based process, and so there are some things we can do and some things we can't do. But I understand the concern. I understand the concern about upstream risk also, so we will look into those issues that are being raised in the public process. I think with that, I would see if I think Ali is on the line and available if he wants to provide any more detail.
I do not see Ali anymore.
Okay.
But as you mentioned, Deputy Director Felden is with us if she happens to know.
Chair George, members of the commission, this is Leah Felden for the record. And the only additional piece of information I have right now is just that Director Whitman's correct. We did extend the public comment period, and it is open through June 5th at this point.
Okay, thank you. So we're still in it now. There has been an extension to
Correct.
June 5th. Okay, thank you. Commissioners, do you have any other comments or questions on the director's report or issues you wanted to talk about? I think the director has a little bit more for us as well. I think you're muted, Director.
My apologies, Chair George. For the record, Richard Whitman, this will take 30 seconds. I wanted to give the commission a very high level picture of other rulemakings that are coming to you over the next couple of meetings. And this is something that I've been talking with Deputy Director Felden about. Well, we're going to make this part of the regular director's report to you to forecast out 6 to 12 months in advance kind of what is coming to you. That's something that it really occurred to me as I was getting ready for this meeting that we really should be providing to you. So just very quickly, I'll do this verbally. In July, we're going to talk about the fee increases. Again, we've already talked about that earlier today. Those will come back to you. In September, there will be a significant rulemaking coming to you regarding a new program, the Prescription Drug Take-Back Program. This is a product stewardship program under which the manufacturers of, in this case, prescription drugs will be responsible for a program to take back unused prescription drugs. And that has been in the rulemaking process. Well, it's starting the formal part of the rulemaking process right now, actually. There'll be public hearings in June on the proposed rules. So that's September. This product stewardship program is, you'll be hearing more about product stewardship as a theme for our materials management program as we look at other things. The legislature is considered proposals around things like mattresses and other consumer products that represent a challenge in terms of disposal. But the drug take-back piece is important for water quality purposes in particular. Then in November, there'll be a rulemaking around the settlement with Volkswagen for diesel emissions associated with their bypass devices. There's a grant program that is funded with those settlement dollars that requires rulemaking. And then I know a couple of commissioners are particularly interested in outstanding resource water designations for Waldo Lake that we've talked about previously with the commission, and also for Crater Lake. Those will be coming in November, and we will try to find a way to get interested commissioners to at least Waldo Lake, if not Crater Lake also, sometime between now and then. And then there'll be you've seen a couple of hazardous waste delisting rulemakings. That's something we have to do by rule. There'll be one for precision cast parts that comes to you in November. So that's just a little bit of a preview of some of the things coming to you over the next 4 or 5 months. And as I said, we will put this in as part of the regular director's report so you can really see for your policy-making agenda the trajectory of the issues that are coming to you. This, you know, I felt this was important, particularly with the governor's executive order on greenhouse gas reductions. There's a lot of policy development there. And so I want to make sure you've got a full picture, and the public has a full picture of the full plate of everything coming.
I find that very helpful.
Okay, any questions from commissioners? Sorry.
Okay. Commissioner Brasso?
Hi, Richard, thank you for the update. I guess I just wanted to hear again, because I didn't hear in detail, I guess two questions related to vehicles. One of them is just the report that we've talked about. I know we've talked about that a lot. I guess are we going to hear about that in July? It seems to be always pushed a little bit further out in terms of this report. And so I'd love to hear just when are we going to hear about that report and what's sort of taking so long? And then two, just I'd love to hear again what that piece was around the medium and heavy duty vehicle sort of policy exploration that will come back to us. I just wanted to hear that again, because I think when I hear that, I heard that well.
All right, I actually am going to look to Deputy Director Feldman to see if she can talk about the off-road inventory and timing of when we'll be able to talk to the commission about the inventory. And I'll handle the other piece.
Yeah, are you still with us?
We can hear you now.
Okay. Complicated situation I have here with a laptop and some desk monitors and trying to get the mouse to work on both, sorry. For the record, Leah Felden. Yes, so the off-road inventory, there were some more delays in receiving that report. My understanding is that we just received the report. So we do have it. We did conduct a webinar on that report. So I guess I could offer the commission some options. I think staff were hoping to maybe bring the report as well as some context and some other program considerations and some policy options to the commission, perhaps later in the year, which is why you heard, not bringing this in July. But an option, and we have the report, an option would be to just bring you information and a presentation on the report sooner. But I think staff feel that they don't have enough time right now with everything going on to do kind of that full-fledged policy analysis that we've talked about doing, that looks at all the different programs we have and then takes that report, enters that into the mix, and then starts to, I guess, daylight some of the policy gaps or some areas where we might want to focus. So staff would like some more time to bring that to you in a really robust and accurate way. So I suppose it's an option for the commission, whether we just bring that report sooner and come back or bring it all together.
I guess offline, I'd love to just talk through that, because I know that there's a lot of there's a lot there, and how you take in that information and learn takes time often. So I'd love to talk to that offline. But thank you.
Well, and I, wouldn't mind listening in or participating as well. I would definitely be interested in some option that we felt made sense of getting the basic, information collected in the report sooner rather than later. This is not an area where I have, a tremendously rich background, and so I'm very much learning as we go. And I think the more I have an opportunity to read something like the report or summary or go through the graphics and spend some time with that and learn about it and really feel that I am coming to the table with a better understanding before we start talking about regulatory gaps or policy proposals, I would really personally appreciate that extra time and the opportunity to spend some time in advance on where we are today.
That sounds great. Chair George, Vice Chair Barrasso, we can do some offline conversations, and we can bring maybe some information on that report to the commission sooner than later, so that we can start maybe building up to a policy discussion as you suggest.
Thank you.
All right, thank you. And then Chair George, Vice Chair Barrasso, with regard to the California standards, there are two main parts of what California is looking at. One is a requirement for zero emission vehicles for medium and heavy duty vehicles. These are your everything from pickup trucks up to your very heavy semi trucks. And so there, as with the passenger vehicles, California has minimum requirements for sales of new vehicles in the state for zero emission vehicles. Oregon has adopted those requirements for light duty vehicles. The option here would be to do the same with regard to medium and heavy duty vehicles. That's one piece. And then the second piece is with regard to emissions from, again, those same vehicle classes. California is considering adoption of clean, very clean engine requirements for diesel trucks in terms of both NOx emissions, nitrous oxide, and particulate emissions. And again, under the Clean Air Act, Oregon could adopt those tailpipe standards for medium and heavy duty trucks. Those would be requirements for sales of new medium and heavy duty trucks being sold in Oregon. So this does not address directly the existing fleets. As you know, House Bill 2007, adopted by the Oregon legislature in the 19 session, to some degree addresses existing fleets by phasing in requirements in, I think I'm going to get this right, in the Portland metro area over time. So neither of those is a comprehensive approach to the entire fleets, but they're both potentially important pieces. And what I'm trying to signal is we're looking at how to put some of these pieces together in a more comprehensive way to address some of the underlying concerns that we believe motivated the petition, the indirect source petition. All right, Commissioner Barrasso, did that give you enough for the moment?
Yeah.
Okay. All right. Chair George, with your permission, we have, I think, one more agenda item, which is an update on the agency's policy option packages and legislative concepts. And let me just do a process check here to see whether we have Nancy Bennett available. It looks like we might. And I think she is the main presenter on this piece. Nancy, are you there?
I'm here. Can you guys hear me?
Yes.
Yes. Nancy, I'll do a 30-second intro and then hand it over to you. Okay. We've had a lot of conversation today about COVID and the impacts of the pandemic on everybody and everything, including health impacts, but also impacts on the economy. So having that going on at the same time, we are preparing proposals for the legislature to consider in February and March of 2021 has been a very difficult exercise and continues to be. We are expecting a revenue forecast on the 20th of May. We are expecting that revenue forecast to forecast a reduction in resources, both for the current biennium through the next year, and then also for the 2-year period after that. So we have already started to scale back some of our ask for the legislature for the next long session. I think what you see in the what you're going to hear about in the presentation today is kind of an intermediate proposal, if you will. It is less than we were looking at even a few weeks ago. But it's also possible, if the economy continues to deteriorate, we will get instruction from the governor and Department of Administrative Services to scale back even further. So that's why I call it kind of an intermediate proposal. There's so much uncertainty about the future of the economy. We're trying to hit a spot where we don't completely abandon some of the important priority work that we think the agency should be taking on, but also not wanting to be oblivious to what is going on around us in the economy. And so with that introduction, Nancy, please go ahead.
Okay, thank you. Well, good afternoon, commissioners. It's nice to see you over our video today. For the record, I'm Nancy Bennett, Policy and External Affairs Manager. With me presenting, I hope, I'm not seeing them yet, but I think they're there, Annalisa Bhatia, who's our Senior Legislative Advisor, Matt Davis, our Senior Air Quality Policy Advisor, Abby Baduris, our Senior Land Quality Policy Advisor, and Ryan Huff, our Senior Water Quality Policy Advisor. So as Richard mentioned, today we'll be talking about our proposed budget request for the 21-23 biennium and our proposed legislative concepts that we hope to bring forward in the next legislative session next year. So this is an update from the presentation we shared in January. Obviously, as Richard just talked about, a lot has changed since then. Back in January, we were sharing high-level priorities, and I think was a more expansive list of things that included some critical must-have items, but also areas we really wanted to expand. And since then, we've done a lot of recalibrating. We have shared and discussed budget ideas with our agency leadership team and managers. Last week, we held a stakeholder meeting with a broad group of environmental, local government, and industry interests. So I feel the list we're presenting today reflects those conversations. It's been pared down to critical must-have items. And these are really the investments that we think are needed to sustain momentum on core projects like water quality permitting, modernizing our recycling system, reducing greenhouse gas emissions, emergency response, our EDMS technology project. The funding sources for these requests will primarily include a mix of state general funds and fees, sometimes in both, sometimes just one or the other. So we'll talk about that a little bit. Again, acknowledging what we've been talking about, the state of the economy is very unknown, the state of the state budget is very unknown. So this is where we're at today, and we'll continue to evolve as we need to. Before I turn it over to policy staff to share specifics, I do want to take just a minute or less to talk about the budget process. I just want to make sure anyone who's out there maybe listening to this just kind of has a sense about where we're at in this process. So reminder that Oregon has a 2-year budget cycle. The budget development process has 3 major phases. So there's the agency request budget. That's what we're doing right now. The governor has a governor's recommended budget and then the legislatively adopted budget. We're at about the midpoint in the development of our agency request budget. We will likely be making decisions about which policy option packages, these are the new investments. We'll decide what should move forward probably by the end of June. So feedback is going to be really important sooner rather than later. We'll be continuing to sort of fine-tune agency narratives and other aspects of the budget process this summer, and we submit the budget actually September 1st. Then the governor will consider our requests in developing her governor's recommended budget, which is typically released late November, early December. And then in 2021, we'll be working through the legislative process with final adoption of our budget about a year from now. So that just kind of gives you a little bit of the sense of time frame that we're dealing with. We welcome and look forward to your input, commissioners, today and in the coming weeks. We're also really eager to hear public input, and we have been getting some, and we'd like to hear more. We'll have a place on our homepage that's a little bit more prominent where you can get information about our budget and submit your comments. The documents that we're going to have showing today will be there, and also they're on our EQC page if you're interested in following along. So with that, we're going to start out with the policy options, and then we'll move to the legislative concepts. So let's go ahead and turn it over to Matt Davis to talk air quality. And hopefully.
Great. Good afternoon. Can you all hear me?
Yes.
Great. Good afternoon, Chair George and commissioners. It's been nice to see and hear you all today. Again, for the record, Matt Davis, Senior Policy Analyst for the Air Quality Division. So I'm going to walk through the packages in order that they appear in this table and just providing a little context around them. I'm not going to read them, so we'll just dive right in. So the first package relates to House Bill 2007, which Director Whitman kind of briefly touched on in his director's report. You'll recall that bill prohibits the registration of older, medium, and heavy-duty diesel engines only in the Portland metropolitan area over a series of deadlines, the first of which hits in 2023. There's an important exception to those deadlines, though, for trucks that have been retrofitted with enhanced emission control devices. And while ODOT's responsible for implementing those registration prohibitions, it's DEQ and the Commission's job to develop and implement a program for certifying and verifying the installation of those retrofit devices. So when the bill passed in 2019, DEQ submitted a fiscal impact statement requesting 6 positions to fully implement the program. The legislature authorized 2 to begin the policy and planning work, and the Legislative Fiscal Office directed us to come back during the next long session, the 21 long session, with a little more refined, detailed request about what we would need to implement that first 2023 deadline. So that's what this package represents. It's 2 positions and some one-time money related to software upgrades that we'll need to kind of manage this new program. So I'll move on to asbestos. I'm sure you all know asbestos is a naturally occurring mineral that was widely used in construction materials for many years. It's also a potent carcinogen that is kind of found throughout the older building stock. So DEQ, we regulate surveying, abatement, and disposal of asbestos containing and potentially containing materials. The program does a variety of activities, including permitting those abatement projects. We inspect projects for proper surveying and handling practices. And we also spend time giving technical assistance to contractors and homeowners. And then additionally, the department accredits third-party entities that are responsible for training and certifying contractors to perform that work. The package, this package that you see here, proposes to raise fees sufficient to raise about 20%, an additional 20% in revenue. And this is to maintain the current program and our operations as they exist today. Similar to other fee packages, we would request that the legislature authorize an increase, but that we would, kind of hearing, sorry if that's, I don't think that's on my end, the background. Anyway, we would request the legislature to approve the fee increase, and then we would work with stakeholders through a rulemaking and you all to determine exactly how that increase might be implemented. So the next one is relating to all of the work you heard about this morning from about Governor Brown's Executive Order 2004. But while the legislature already authorized 10 positions to begin that work, we fully expect we'll need additional positions to fully implement the programs that result from that policy development work, in particular the cap and reduce programs and also the statewide transportation strategy work plans. So right now it's too early, obviously, to know how many positions we would need or how exactly they would be funded. So I would just characterize this as a kind of a placeholder in our budget that will have more specifics as we move further and further into that work. The next package is essentially the tool to seek legislative approval for a permanent fee increase for the vehicle inspection program that would reinforce the temporary increase you all adopted this morning. It's also the budget mechanism that we have to use to restore the 8 permanent inspector positions that were cut at the end of the 2019 session that you've heard a little bit about. So this package, you know, it really represents kind of the budget mechanics behind all of the fee increase work that you talked about this morning. And then finally, the Lane Regional Air Protection Agency is Oregon's only local air district. I know you've heard from them and their director, Merlin Huff, in the past. They're a really critical partner for the EQ's air quality division. They implement nearly all of the state's air quality regulations and programs within Lane County. So during the last recession in 2008, ORAPA experienced really significant reductions in their general fund support that they received from the state, close to a 40% reduction. And while DEQ has seen our general fund support restore to pre-recession levels, ORAPA never has yet to see any kind of restoration. And as a result, they find themselves increasingly unable to implement really core programs. It also creates inequities in their funding model, which relies on state general fund support, permit fees, and local dues from Lane County and the cities within Lane County. And just to give you a sense of that work, they use state general funds to support their air monitoring efforts, their homewood heating work related to fine particulate matter, complaint response, and community education work. And I would just say, well, it's kind of conceivable that ORAPA could receive general fund in a one-time manner directly from the state legislature. Working with us and having the pass-through funding be incorporated into our budget really gives them much more stability and predictability, gives ORAPA that predictability and stability. And that's why we have been partnering with them really since last session to put this particular package together. So, thank you.
Great, great. Let's go on to land quality. Abby, can you start talking?
Good afternoon. Can you hear me all right?
Yes.
Yeah. Okay, great. Well, good afternoon, Chair George and members of the Commission. For the record, I'm Abby Viduris, the Land Quality Legislative Analyst. As you know, the Land Quality Division is a coordinated group of programs encompassing underground storage tanks, emergency response, hazardous waste, environmental cleanup, and materials management. Each of those programs are governed by their own state and federal statutes and are funded by over 20 different dedicated fees. The land quality programs receive only a tiny amount of general funds. These programs are on a spectrum of fiscal resiliency, with some appropriately resourced and others at the risk of insolvency. There are 5 items on the list in front of you from land quality. Some are standalone POPs and 2 are POPs supporting legislative concepts. Both legislative concepts are placeholders at this time, as we need more time to develop them and work with the stakeholders, a process that, as you can imagine, has been much more challenging in remote work. First is a POP to stabilize the emergency response program. Back in November, we provided the Commission with an overview of the program, but as a refresher, the Emergency Response Program works with other agencies and industry to avoid and respond to spills of oil and hazardous materials to minimize the impacts to people, property, and the environment. DEQ prepares for future disasters and responds during emergencies. The program responds to approximately 2,000 incidents a year. The work requires training, planning, coordination, and round-the-clock response ability. I will highlight that this past February, there were floods in Eastern Oregon, tanker truck spills, and sinking vessels, all requiring a response from the program. And as you might imagine, the expertise of this program has been in great demand during the current pandemic. The work, however, is not adequately resourced or funded. Over the past several biennia, DEQ has sought additional positions and funding. These funding requests have, however, have not been successful, so DEQ's capacity to respond to emergencies is quickly exhausted when responding to sustained events or multiple simultaneously occurring emergencies. Due to limited resources, DEQ is also not able to inspect most spill sites to confirm that the cleanup was completed to regulatory requirements. And when this happens, and we fail to identify sites with incomplete cleanup actions, it can lead to future long-term cleanup sites that require additional resources and cost to complete that process. This POP includes 5 FTE funded by a variety of funding sources, with the specifics really still to be ironed out. The next on the list is an LC and a POP to modernize Oregon's recycling system. Back in January, we provided you a briefing on the program's efforts around recycling. We described how the Materials Management Program has conducted extensive research and has been working with the statewide stakeholder group, the Recycling Steering Committee. And that committee's charge is to modernize Oregon's recycling system in response to the major disruption to global markets for recycled materials like you put out in the bin curbside. Work is continuing, and in fact, I just got off a Zoom meeting today with the Recycling Steering Committee. We have, though, submitted a placeholder only to update that system because we do still have quite a bit of work to do. There will be a corresponding POP funded by other funds as needed, and we'll determine that once we work out more details. Third on the list is about hazardous waste fees. We've submitted a placeholder LC and a corresponding POP to restructure the hazardous waste fees. Those charged to a subset of hazardous waste generators, and also the fees charged at Oregon's hazardous waste landfill. These fees support both the hazardous waste program and the environmental cleanup program. A bit about the cleanup program. The cleanup program relies on a complex variety of revenue sources, which include cost recovery for work done, fees, federal grants, and bond sales. The program's internal systems and funding structures have remained largely the same since its inception 30 years ago, and will be needing some update. But as the population grows in Oregon and industries evolve, DEQ's cleanup program faces new opportunities and new challenges. Statewide, former industrial sites are being redeveloped for new purposes, and DEQ often works on smaller sites that require quick turnaround due to real estate transactions. And meanwhile, DEQ is called on to engage residents in the neighboring communities where it provides the essential oversight of these cleanups. But over the past 2 decades, revenue sources have declined while we've adjusted programs and responsibilities to meet those changing needs and expectations. The program is operating with fewer filled positions despite greater pressure on staff and management. Simply put, the cleanup program's funding levels no longer sustain the work required. We'll need to modernize the program and stabilize the funding. Next is a simple POP to seek permanent position authority for 2 limited duration positions that the Solid Waste Orphan Program received as a pilot last biennium. That program would be funded with existing fees, and it supports the cleanup of orphaned solid waste sites. And then finally, there's a POP for our industrial orphan program for the industrial orphan bonds to replenish the bond account that's used to clean up properties where the owner is unknown, unable, or willing to conduct that cleanup. Recapitalization of that account will support DEQ's ongoing need to investigate and clean up contaminated sites where uncontrolled hazardous waste substance releases pose risk to human health and the environment. We've historically requested these bond sale every other biennium. So that's what we have from land quality.
Great, thank you, Abby. And Chair George, I want to make sure that if you guys have questions, you feel free to stop us at any point. So I'll let you notify us if you'd like us to back up on any of these particular items. But if not, I'm going to go ahead and ask Ryan Hoof to join the video here and start walking us through some of the water priorities.
Ryan, we can't hear you.
Chair George, this is Stephanie Caldera, your EQC assistant. I believe I do need to merge his line with the phone line, which unfortunately I was not able to do before, and I am not sure which phone line is Ryan. So Ryan, if you are connected by phone audio, if you can please press *9 on your touch tone system, it should then show me, I have 4 phone numbers in front of me. Which one belongs to you? Okay, and I believe I have now brought Ryan Hoof into the audio portion of the meeting.
Can you hear me now?
We can.
All right, excellent. Thanks, Nancy. And good afternoon, Chair George, members of the Commission. Good to be with you today. For the record, my name is Ryan Hoof, Senior Policy and Legislative Analyst for our water quality programs at the agency. We have 6 policy option packages in front of you today on the handout. In addition to those 6, I also will take the opportunity to discuss the effort and of interest to many different programs across the agency. It's of particular interest to water quality, so I will be covering that one as well. The first 3 items on the water quality list are all related to different sub-programs of our permitting work. And so I want to talk about those somewhat in concert with one another. The first of which is specific to our wastewater permitting efforts. And as you probably recall, the last session, we put forth in our agency request budget a substantial request in this area to really address some long struggles in the agency's part to address a significant backlog of administratively continued permits in this particular area, and to address a variety of resource deficiencies for program work. That was a great success, and we are looking to try to build upon a momentum that really was widely regarded by a variety of stakeholders and key legislators as an initial step during 2019, and looking forward to a multi-biennia endeavor towards continuing this work and gathering some momentum. This particular package started, and I mentioned this in January when we gave you an overview of where we were at on this process. that we started in water quality by first looking at positions that were not authorized from the past request budget. And in the last go around, we initially had asked for 27 positions, and 10 of those were authorized. So the natural spot for us to start for this particular work was scrutinizing the 17 positions that were not, to see whether those were still a high priority. What we found, and again, thinking about this as a multi-biennia effort, and more recently in key recognition of COVID circumstances, we've whittled back the request and the scope of this to somewhere in the ballpark of 5 to 8 positions that would address timeliness and quality of permits being able to be issued for both our NPDES and WPCF efforts. It would be statewide, not just addressing permit development, but also compliance and verification in enforcement areas as well. The agency has dedicated a significant amount of work to improvements in this area, and we're really looking forward to trying to maintain that momentum. And we do believe that additional resources are necessary to do that. The second item, again, another sub-program or sub-part of our permitting work, but this is specific to stormwater. And under this package, we are seeking to add 2 additional positions. One would be a regional position focused on compliance verification work and permit issuance. And a second position would be at headquarters and focusing on policy development. Much of the work that's needed in this area has to do with increased demands, particularly around industrial and construction stormwater permits and work associated with those particular areas. And then third, under permitting and water quality work is specific to on-site septic systems. And this package would seek to add 2 additional positions specifically to address large on-site systems. These are include subsurface treatment systems that commonly serve larger businesses or clusters of residences, such as rural subdivisions or manufactured home parks. The enhanced resources and increased capacity for this program would be very helpful for both permit development, timeliness of being able to get those permits out the door, doing plan reviews, inspections, and providing technical assistance in the field. Moving on to the fourth row or item under the water quality section, I want to talk about some work that we recognize a greater need for resources around clean watershed plans, and really around TMDL work, both TMDL development, but heavily recognizing needs in the area of TMDL implementation. This package would support 3 positions focused on the services and work that our team does, including data collection, data analysis, and other efforts that help support the work of our sister natural resource agencies and other designated management agencies that are responsible for really executing and putting in place these TMDL efforts. This work, from our perspective, in addition to data collection needs and the analysis, often culminates in products such as status and trends reports that help evaluate how those efforts are working, whether the investments are producing the restoration results that are desired, and give us an ability to evaluate the outcomes and whether they're working or not. In addition to those 3 positions, one of these positions would specifically be available and contribute to TMDL development work in a variety of areas, but may also include, or I should say specifically include, some high priority TMDL work in the eastern region. The next item on the list is specific to our Clean Water State Revolving program. That program seeks some additional limitation. I do want to emphasize this is other fund limitation only and no positions associated with this package. But this would be specific for procurement of a loan management software system to replace what is really an antiquated, outdated system, and put in place something that is much more secure, that would increase efficiencies, improve customer service capabilities for the program, and reduce the risk for material errors for a program that manages a significant volume and dollar amount of loans. I should note that with this particular package, the 2019 legislature did provide some initial funding for early scoping work around this project, and so this would be the next phase to actually do the procurement for that software. The next item is specific to our 401 water quality certification program and seeks one position under general fund support to increase capacity for that program. And really this is about a variety of work involved with that program, its ability to ensure compliance, measure program effectiveness, provide a variety of technical assistance capacity in the field for different stakeholders who are seeking 401 certifications on different projects. And then the last item, the sixth item under water quality, is a package that would support water quality's only legislative concept that we currently have drafted going into the next session. And this concept is to develop a request for proposals for an evaluation to look at how effective the laws and programs related to groundwater quality are working around the state. Our agency recognizes that there's been a decreased investment in this work and that it's probably time to provide a look, and not just internally from within our agency, but because of the interagency aspect of this work, because of the variety of stakeholders and their interests involved, that an evaluation to see how well this program and these laws are working is due. And this also would establish a interagency task force that would be able to evaluate that work and perhaps make some recommendations for how the program moves forward in the future. The policy option package specifically would provide $250,000 in contract services, no positions at DEQ, but to support that work. And then, as I mentioned, I do want to note on behalf of the lab and other programs with interest at the lab, the lab infrastructure policy option package. And this really seeks to add additional base funding for the lab for the ability to maintain and replace aging equipment that they have out there. It really would increase the ability to replace equipment on a schedule that's optimized for full use of that equipment while advancing technology as work demands change. It also would provide increased ability to be able to maintain different equipment through ongoing service agreements through the S&S funds that are requested as part of this package. There are also two positions noted here, and I think that's still an area of discussion about the priority for the agency, but there has been a very high staff to manager ratio at the lab. There also is increased workload that is taking place at the lab in terms of just facilities management and general support that's needed there. So that's what those two positions would address. That's all I have for the moment. I'd be happy to take any questions, or Nancy, if you want to move along to the agency management pops.
Okay. Well, Nancy, before you do that, I just had one quick question. So I certainly noted the TMDL implementation and watershed work on the list. Would the work that we're trying to do, which right now is very much at a planning level, but with our kind of sister agencies in agriculture and forestry, are we anticipating that that's going to be simply at a planning management level for a bit longer, or do we have what we need to start moving that work forward when we're ready to do so?
Chair George, I appreciate that question because indeed this package, in addition to the personnel that I mentioned and how they would be associated with the different aspects of TMDL development and implementation work, in addition to that, we also are seeking some one-time contract service dollars, really about developing those tools that really on the ground help us to have the data that we need to have that dialogue with our sister agencies about the various needs. And so I do believe that it's not just about planning, but really getting at some of these core issues about what's needed on the ground.
I agree, and I think and hope, and we'll go to you, Director, that's, you know, where we're going. We're doing all this work now, and that's great. But, you know, several of us have kind of reacted to very lengthy planning schedules that have been proposed and said, hey, we need to do the planning work at a high level, but we need to empower the people who are down on the ground in the watersheds working with the communities. We need to bring resources forward so that we can get these projects going, more of them in more places. And so that's just kind of my thought, is I want to be sure that, because especially I've heard from our sister agencies that they don't have all the resources they need. I want to be sure that to the degree we can, we are going to be ready to provide the needed support so that we really can get more of these projects going out in the watersheds. Director?
Thank you, Chair George, and thank you, Ryan, for your work in presenting this. Just a couple of comments. One, we are continuing to talk with leadership in the Oregon Department of Ag in particular about coordination of our budget request in this area. So just be assured that that work is going on. Number two, for DEQ, this particular request really is focused on the implementation part of TMDLs more than the development of TMDLs. We have TMDL development work to do, but this is really about accelerating the work on implementation of those plans and actually achieving change on the ground. And then the last thing is really just to emphasize something that Ryan said, which is the technology in this area is evolving rapidly, and our ability to identify opportunities where improvements, you can get the most bang for the buck in terms of investments, number one, and perhaps number two, also where things are going in the wrong direction and need to be turned around. Both of those things, the technology is changing rapidly, and so some of this is also to make investments in that developing technology so that we can provide the data-driven feedback to whether it's Department of Agriculture or Department of Forestry or others about how they can carry out their work in the most effective way.
Okay, thank you.
Okay, I think I'm going to just...
just one moment before you proceed. Commissioner Addington.
Oh, absolutely.
Thank you, Chair George. Just quickly, Ryan, for you, two quick questions. The Clean Water State Revolving Fund item, the other fund, can you explain what that means? I mean, I understand the software, the legislature did something in 2019. Can you just go through that again for me?
Sure. So as part of our Clean Water State Revolving Programs work, much of the funding is passed through DEQ to provide loans to local jurisdictions for their needs. And part of the ability and the administrative authority for administering that program at the state level from those funds that come through from EPA is the ability to use some of those dollars, a very small percentage of them, mind you, for administrative purposes. And so it would be about us tapping into those dollars. We just need the limitation authority from our legislature to use additional amounts of that pot of money for these types of purposes.
Okay, thank you very much. And then just one question on the groundwater item. And I think Richard might have touched on this a little bit. Just how does that work with the other agencies? Are they, obviously I'm assuming you're in coordination with them about this concept. Do they also submit a concept, or do you do it jointly? How does that work?
You are correct. We have been in discussions with our sister agencies. Those that have a particularly strong interest in this would include ODA, Water Resources Department, OWEB, Department of Health, OHA rather, amongst others. And at this point, they don't have any need around this particular legislative concept or a need for a policy option package to go forth simultaneously with ours. The money requested as part of this package would support the contract for the evaluation and to provide some money to support task force work and coordination of the task force. There is the possibility that agencies may evaluate this and do a fiscal impact statement on a legislative concept once it becomes a bill and determine that they might need some resources to support their staff time to participate in a task force effort like this. That is yet to be determined and will require some further discussion about the scope and needs of the task force work.
Thank you.
Okay, now I'm going to move us along very quickly here, agency management, and then we still are going to talk legislative concepts for a moment. So just quickly, support staffing. The 2019 legislature approved over 50 positions for DEQ. Those were focused on sort of programmatic areas. What we did not get were sort of the support positions that are part of our central services office. Things like HR, IT, and payroll. We were told to come back during the short session and sort of see what we needed and bring those requests. Obviously, the short session didn't really happen. So we have been able to hire some limited duration staff. We have a pretty skeletal crew that I think are functioning in those support positions in HR. And so they've done a really fantastic job, sort of given their limited resources. But we are seeking some permanent positions in the next session. These will be funded through agency indirect, so we would not be seeking new general funds for that. The second item is related to our EDMS project, which I know you're familiar with. We're excited about the development of this and launching that soon. The legislature approved bond funding for the acquisition and customization of the system, but we have some ongoing contracting costs associated with hosting and maintenance. So we are exploring an option related to sort of a cost recovery through a transaction fee. Annalisa is going to talk a little bit more. We have sort of a corresponding legislative concept to this. We're really working through sort of the economic modeling of this. We know what the final cost is. It's $800,000 a year, but I think determining sort of what the impact on the users of the system is a piece that we're still modeling out. We're going to be having, I think, a lot more conversations with stakeholders, and we want to be very transparent about this piece of it. I felt like this was the most transparent approach to funding this aspect of the system. So I think there'll be more to come, but we just wanted to keep this on our list for now. So are there any questions on the policy option packages before I throw it over to Annalisa to share very quickly what's going on with our legislative concepts? Okay, Annalisa.
Hi, can everyone hear me?
Yes.
Okay, great. For the record, Annalisa Bhatia, Senior Legislative Advisor. I would agree with Nancy, it's great to see everybody, but I also recognize that I am the last thing at the end of a long meeting, so I will try to be brief, but please feel free to wave your hand and jump in at any point. It's been quite some time since we have discussed legislative concepts together, so I also just want to begin by reminding everyone of where we are in the LC development timeline. Since we last met with you to talk about this, we have been required to submit our draft legislative concepts to the Department of Administrative Services and to the Governor's Office for their initial review. Shortly, actually, tomorrow morning, we will be meeting with both of them to discuss these ideas a bit more in depth and receive preliminary approval to essentially start getting these concepts drafted. That will take place over the next summer months, and then the timeline really meshes up with the budget process in terms of the governor's request budget coming out and final approval, and then of course the bills would be, if approved, able to be dropped in late December. So just kind of, that's where we are, but I also want to acknowledge that even though the timeline and the instructions for developing of these ideas have not changed, with the onset of the COVID emergency and the economic situation, we've been in really close communication with DAS and the governor's office. And I would just emphasize that there's still a lot of time for discussion. There's a lot of time to really weigh these options and whether or not it's the right time to move forward. So recognizing some of the conversation that has already happened today, I just wanted to put that out on the table. Many of these LCs have already been referenced by my colleagues during the POP discussion, so there may be some that I only briefly mentioned, but again, if there are any questions, feel free to interrupt. First up is, and this is the kind of green shaded list that was also accompanied in your report, is a legislative concept related to EV rebates. As you probably know, the Oregon Clean Vehicle Rebate Program is set to sunset on January 1st, 2024. And these rebates have been really critical for meeting our statewide goals of EV adoption. And then as we're moving on into the greenhouse gas work that has already been talked about today, it just remains a critical tool for the state to really meet some of our goals. So in order to continue to support the adoption of clean vehicles, this would affect the sunset date. It is a placeholder right now. We are still engaging with stakeholder conversations, and really the program's evaluating based on those conversations what that right time frame is. So that is something that is to be determined. But that is something that we are really considering and looking to move forward. Next up, also in the air quality world, is the placeholder that Matt mentioned. This legislative concept accompanies the POP. And right now, I would say it is a true placeholder as we develop our plans and needs related to the executive order. We're moving through the language and looking at what other clarification may need to take place. This is something that as we develop those plans and really work through what is needed, we expect to identify different pieces that really would clarify and make our program stronger and more effective and efficient. One piece I would mention that we are looking at is related to our enforcement authorities and really making sure that the economic benefit of not complying with the program does not outweigh complying with the program. So that's one piece that we expect further conversations around. The next, for land quality, I am going to essentially skip over because I know the commission has heard a lot of different briefings about our recycling program, and then also Abby just covered it really thoroughly. So if you have any questions on that, please let us know. I would just emphasize again, right now, this is a placeholder, and you'll notice that most of our legislative concepts right now are placeholders. And while that's a tool that we have always utilized, I would say that right now there are more than we normally would have at this point, partially just because of the stakeholder work and some of the added communication challenges that have been associated with the world we are in right now. The next up is also one that has been covered pretty thoroughly, so I will just acknowledge that the hazardous waste fee structure monetization is a piece that needs to be done in bill form because these fees are set in statute. So that's why we have both the POP, the kind of financial side of things, but we'll also need to actually change that legislative language. Again, the evaluation of the Groundwater Quality Act has already been mentioned. I'm not going to move into that too much, other than also just seconding what Ryan covered at the end. And Commissioner Addington's question, we've been working with our sister agencies quite a bit and really been having some conversations with them about what we all would like to see, what different issues should be mentioned that maybe DEQ hasn't thought about yet because it comes up for water resources more, or that's just an example. This is something that we're really looking to be coordinated on and really looking to provide a really robust conversation about the Groundwater Quality Act so that we can really have an understanding of what is working and what maybe still needs some further work in the future. Now moving down to the environmental justice legislative concept, this is also a placeholder. Environmental justice is an issue that is obviously incredibly important to DEQ and is critical. It's a critical aspect of how we think about our mission. For some time, there has been some conversations with the governor's office, the EJ task force, and other agencies that do similar work about the overall vision and how can those agencies and the governor and all those folks strengthen the state's capacity to engage with those communities that are disproportionately affected by pollution and climate change, and how can we can formalize and support the EJ task force in a stronger way. This legislative concept is a placeholder for some of that work, for some of that conversation. I would say that there are still some specific changes that are being developed. That's partly why it's such a placeholder, through conversations with the governor's office and specifically with DLCD's Climate Adaptation Framework and OHA's Climate and Health Programs Equity Work Group, both of which have work products that are being finalized in the next month or so. And so we expect to have multiple meetings with the governor's office to really talk about some of those different pieces and flesh out this legislative concept a bit more. So that is one that I would say we're holding this bill as a mechanism to continue that work, and I would expect to be able to provide some more information about that in the future. And then finally, you will see we have actually two legislative concepts related to the EDMS system. I'm going to speak about them together, but again, they are two separate legislative concepts as they're being drafted. As we implement EDMS, DEQ expects a much greater percentage of transactions to be made through credit card payments. And if you're unfamiliar with that mechanism, the entity that is making the charge, in this case DEQ, is charged by the processor an extra fee that's a percentage of the transaction. What we are looking for would be to be able to pass through, they're called convenience fees, which is really nice and friendly. We're looking to pass through those convenience fees that are charged by the credit card companies when people use a card. This is similar to what some of our sister agencies have done for other programs. So we're looking at the way they have that authorization in statute, and we're developing a bill based on similar authority to what has already been established by the legislature in the past. The second EDMS alleged concept would create methods by which DEQ can recoup some of the cost that Nancy mentioned for the ongoing licensing and hosting costs of this platform. We're looking at developing language to cover these costs in a way that's fair for all users of the EDMS program. And as Nancy mentioned, we're looking at both working out the details for the mechanism, and then we'll also be engaging with our stakeholders on this process to make sure that that mechanism is workable for everyone. So more to come on that. I'll pause there for any questions related to legislative concepts, and then I just wanted to say one more piece on the legislature kind of going forward. Okay. I just wanted to say I've heard a few questions about legislative action today, so I thought it would make sense to end by touching on legislative days. As you probably maybe have started on your calendar and already marked, because I know I do, regular legislative days were scheduled to take place beginning on May 20th of this month. Those have since been postponed, with the exception of revenue committees, and likely E-Board will still meet that week to hear the revenue forecast and really do some of that work. What we are now hearing is that regular policy committees will meet remotely in the following week. So more specifically, they're looking at House policy meetings happening in the last week of May, and then Senate policy committee meetings happening in likely the first week of June. Nothing has been formally scheduled, so there haven't been meeting postings that look out, but we have started working with committee policy staff to think about what informational presentations may make sense and what requests may come to DEQ. So I always try to provide you with a report of DEQ's actions during those ledge days. So as those progress, we will be providing you with that information. And then as a last thing, special session has also not been scheduled, but I know discussions are ongoing about meeting to address COVID response as well as the economic situation, and whether those would be the only issues discussed is kind of a to be determined as well. So as we get more information, we can be sure to share it with you.
Thank you, Annalisa. So that wraps our presentation up this afternoon. We're all here still to answer questions, or you can reach out to us later. I know we're a little past our time, so I want to respect your schedules today, but we do appreciate your attention and look forward to hearing from you more and talking to you more about all these issues.
All right, thank you very much, everyone, for that overview. Commissioner Kyle?
Yeah, just thank you for all of that. And that last little bit about the EDMS and things like that, again, it kind of dovetails with some of what was on the agenda today. Some of the public comments, I think it was mostly in the water permit and DPS, just saying how important it's going to be to try to digitize some of the permit making and permit processing, and I think those are tied together with some of this EDMS funding. So again, it's just kind of linking all of these actions together and making a compelling case, because that is kind of the heart of this, and it would be where a lot of the efficiencies and just ease of permitting might be found. So just more of a comment. It's usually it's not a very exciting topic, but it is one that is super important and would benefit both the agency as well as the permittees.
Absolutely, couldn't agree more. Thanks.
And Commissioner Addington.
Thank you, and thanks Nancy and Annalisa and your guys' team. That was really helpful and good. I'm just going to ramble for a second, and then there's going to be a question here. And I don't know, maybe it's Richard's question, maybe Nancy, it's yours. I don't know how this works exactly, right? So if we have these policy option packages and these legislative concepts, and, you know, we know that there's budget issues looming, right? And Richard, you alluded earlier to, you know, already paring this back a little bit because of that. I guess I don't know. I guess it's up to us as commissioners to make this decision maybe, but I'm interested in Richard and staff, your guys' thoughts. Is it incumbent on us? I mean, should we be prioritizing some of these things internally? Just recognizing the economic situation we're in, or do we just sort of throw everything out there and let the legislature do all that?
Well, I have some thoughts about that. I'm sure the director does. I guess in my experience with this work, I think you do a bit of both. I think it's, you know, for one, there's different stakeholders that care about the different pieces of this work. There are different fee payers. There's sort of different funding mechanisms. So I think we need to kind of marry that together. I absolutely agree, though. We will prioritize this. And certainly I think in the governor, you know, when she puts together her governor's recommended budget, she's going to pick and choose what policy option packages get included in that. So she might pick some of our items, she might not include some of our items. And then legislators will have their own priorities, and they often reach back into the agencies and, you know, pick up things that they see we're doing that they want to do. And I think it's really unknown what that revenue picture is going to look like. It certainly feels like it's going to be pretty dire, to be honest with you, next session. And so I think it's really good that we continue putting our needs out there with kind of a healthy bit of you know, recognition that we're going to have a tough hill to climb on a lot of this, quite frankly. And I think we will have to come back and probably pare it down. I think at this stage, it's okay to have a bigger list. And this is the pared down list, but I think it's still okay to have something at this level. So I'll see if the director has any further thoughts.
Director.
Thank you, Chair George and Commissioner Addington. It's a great question. And I'm just going to reflect on my experience with this over the last almost 15 years now, both as director of a smaller agency, then being in the governor's office, and now being director at a larger agency. One thing I really noted, if you don't tell people what you need, you're not going to get it for the most part. And so this is my personal opinion on this, and obviously the commissioners are entitled to their own views, and ultimately it's your decision. But I tend to ask for more than I think we're going to get. I don't expect that we're going to, in the last regular legislative session, we made a very conscious decision to ask for what we think we need. And that was a lot. And we got maybe a third to a half of what we asked for. And that was, I think, frankly, pretty good. I think we viewed that as a successful process, and respect the decisions that were made by the governor and then the legislature in terms of weeding out what the priorities are and what they felt they could fund and couldn't fund. But if you start by self-limiting what you're asking for too much, then you're really putting yourself in the institution at a disadvantage. So that's tough to do for me, and I think it's probably tough for each of you to do during this time when we see the economy and fee payers, taxpayers hurting. But I am still inclined to ask for more than I think we're going to get, because I think we have to. The really tough winnowing will happen when the governor looks at all of this. We never get a large part of what we ask for, even in the governor's recommended budget. And then in the legislature, it'll be a whole nother set of eyes on it. And that's part of the process, and it's good. It does force us to be clear about what we think our priorities are, and so prioritization is a big part of this. But I also think we don't want to be, my personal opinion is we don't want to be too limiting at this stage of the process, even in relatively tough times.
Yeah, and if I might, Madam Chair, Richard, that makes a lot of sense to me, and I don't have any problem with that. And Nancy, I appreciate your input on that. It does make sense. I'm just sitting here as one of 5 people that, you know, turns around and implements a fee increase or a policy later, or a rule later. I want to be consistent, right? And so earlier today, I've raised concerns about fee increases. I'm new enough, I wasn't part of some of the policy, the POPs that were sent previously. And so I'm just trying to not be inconsistent. If I think there's going to be issues in the future, if I support everything and throw everything out there today and ask for more, am I being consistent if later I then say, I don't know if I like this? And that's just my own process, trying to think a year and a half away from, or maybe 2 years away from now, when this stuff comes back, whatever gets approved by the legislature. So I'm not really for or against anything here. I'm just sort of thinking out loud and trying to process it, and really going through my first cycle here of how this works. So I appreciate that.
Director.
Thank you, Chair George and Commissioner. Just, I know we're late, so I don't want to take a lot of time on this. We've talked about some of it before, but in terms of the discussion earlier today about fee increases, I did not hear the Commission say that the Commission believes the fee increases aren't needed or aren't warranted. What I heard was the timing of when those fee increases go into effect and a little bit of who they're hitting. Can we do something in the implementation to be more sensitive in the timing? I didn't hear you say don't adopt them at all. You may say that when we come back to you in July. That's still your prerogative. But I think what we will come back to you with a proposal is to still have those fee increases go into effect, but over a different schedule that is even more attuned to the current economic crisis that we're in. And I think that's fair. I don't view that as being inconsistent with earlier decisions that were made that the fee increases are needed. We're trying to balance that need of the institution with real economic difficulty that our fee payers are in right now. And so I don't view it as inconsistent. I just view it as we're dealing with the reality of the situation we're in.
Yeah, I totally agree, Richard. And I'm not suggesting the department is inconsistent at all. I just want to make sure I'm being consistent. And I agree with what you just said, by the way. So thank you.
Okay. Anybody else? Questions or comments? Well, thank you, Nancy and team, everyone, for this great presentation. And we'll be hearing more. Director, is there anything else we need to address before we complete our agenda today? It's been a long go, and I appreciate everybody's patience and staying with us and working through all this. Thank you, everybody, for that.
Chair George, thank you to everybody. I think it's very tiring for all of us to be communicating in this way. It takes more energy somehow than when we're together in person. So thanks for your attention during the day. Our apologies for our systems today. We had some more bumps, and we're taking that seriously. We're making sure that we are taking steps to have things go more smoothly in the future. I think we're probably going to have to be dealing with this for a while, and so we are going to spend some time making sure we've continued to improve in how this technology works. And then the last thing I want to say is just, again, we had well over 100 people participating in the meeting today. So on the bright side of this, even though it's more difficult for us all, we're also seeing a lot more people be able to see what's going on in these meetings and understand what you are grappling with. And I think that's a good thing. So there is a bright side to this also. So thank you very much for your attention and your hard work today.
Yes, absolutely. And I see you, commissioners. We'll get you. Yeah, I just want to say, if anybody is still with us, who was with us earlier today, of course, we apologize for the disruptions. I think people are aware these things are happening in the world. It's too bad. It's ridiculous. But I think I really want to commend our staff, our Stephanie, who we know was running like crazy behind the scenes and really got right on it and did what needed to be done. So I want to commend our staff and raise my hands to you. But Richard, I really agree, and I'm seeing this in other forums as well. At the same time, while there are dangers and there are annoyances, it is also making our public processes accessible to a larger number of people, and people are taking us up on that opportunity. So that's a great part of this. And so just want to thank everybody with the patience it took to kind of work through this, and we'll perfect the process here over time. I think we have Commissioner Kyle and then Commissioner Addington.
Kathleen stole my thunder. I was just going to really thank Stephanie for hustling on this. The morning was a little rocky, but I have been on rockier, and you handled it and you caught it and you squashed it very quickly. And I would say that the second half, when we logged in after lunch, has gone beautifully. So I would encourage us to continue to think about this format. It is much more accessible to people as we look to our own greenhouse gas budgets. It is a way forward. So yeah, it's going to take a little bit of adjusting, and I agree it's different energy than in person, but we should not jettison this even when there is the opportunity to perhaps meet in person. This is actually the wave of the future.
Thank you, Commissioner. Commissioner Addington.
Thank you. And I just echo the chair and Commissioner Kyle's comments there. And arguably, Stephanie was one of the most stressed out people in the state today. So Stephanie, you did a great job. I want to just say just a quick thing, I guess, to a placeholder maybe for, and this does not rise as a priority, an important priority with all the things going on in the world. I would like to just, and I'm happy to work with staff or other commissioners or however the best way is. I would like to have a discussion at some point at a future meeting, doesn't have to be the next meeting, about how we handle the briefing materials, how we handle the public comment. And I'm not being critical, I'm just, and I don't know that I have a better idea, but it just seems a little awkward and clunky to me, the public comment part in particular. I mean, this meeting was a tough one just with the sheer, for me, for the sheer amount of material. It was brutal. And I don't know if there's a better way or not. I'm saying this recognizing that I'm the most junior commissioner here, and I don't want to be one of those guys. Every time there's a new commissioner, there's, you know, the briefing packet gets longer. I'd like to see if we can make it more efficient somehow. So I would just like to put that out there as a placeholder. Again, not a huge priority, a lot of things going on in the world, but I'm going to give a lot of thought to whether there's a way to do all that better.
I think that's great. Thank you, Commissioner. Commissioner Mosby, did you have something?
Just, again, hats off to Stephanie. She did a great job. You know, the only thing I've got, I think Richard is on track. He's on top of things in his staff. But the one thing we got to keep in mind, I just made a list here of major employers in the metropolitan area, you know, Freightliner, Gunderson, Boeing out in Gresham, Precision Cast Parts, it's the old Schnitzer, Irvats, I don't pronounce it right. And then there's a handful of forest products companies. They're not completely shut down, most of them, but they've laid people off. I know my former company is down to 3 days a week, just so that people can keep their benefits. This is tough times. It's going to be a while. And hey, we've got rules and regulations we work with them, but before we pile on these new fees, I think Richard, you've got it right. You read it. We've got to work with these people. We've got to give them a reason to come back and work with them and get these people employed. And unfortunately, this is going to be a 2 to 3 year process to getting back to where we were, I think. So again, I appreciate everything DEQ does. I think it's a great organization. I don't want to lose any people, but we've got to be realistic, and we'll see what the legislature and the governor help us with in the coming months here. But great job today. I'd much rather meet in person. I like the energy that comes off of it. But overall, you guys did a great job. And Kathleen, hats off to you for trying to hold us all together here. So take care and have a great Mother's Day weekend, everyone.
Well, great. On that, I'll entertain a motion to adjourn.
So moved.
Does anyone object to adjourning? Hearing none. Take care, everyone. Be well. We'll see you before too long.
Thank you.
Meeting is adjourned.
Thank you all for participating in the Environmental Quality Commission meeting on today, May 7th. At this time, we're going to close the line. Thank you and have a great afternoon.